Good afternoon. So we resume. Señor Bonfiglio tiene la palabra.
Mr. Bonfiglio, you have the floor. Thank you very much, Mr. President, and good afternoon to the members of the tribunal, its officials, representatives for claimants, and also the representatives of the United States that are following us remotely. For the record, my name is Alan Bonfiglio, and once again, it is an honor to appear here before this tribunal again, not only an honor for myself, but also for my colleagues to present Mexico's position and explain the reasons why this tribunal should reject the damages sought by the claimants. In our opening statements, Mr. President, members of the tribunal, and with the help of Oscar Rosado, Gary Shaw, and Mr. Arteaga, we will be detailing the reasons why the claimants have not met their burden of proof. We will also address the three theories of damages put forward by the claimants. And with this, the tribunal will be able to corroborate that these three theories are flawed and exceed the principle of full reparation, so that the only plausible alternative given the circumstances of this case is to consider lost profits. And before analyzing these issues in detail, I will briefly summarize what we will be discussing. Firstly, let me reiterate the claimants bear the burden of proving the losses that they have suffered as a result of the violations found by this tribunal. And we have already explained in our briefs that contractual claims and treaty-based claims are completely different. However, it appears that claimants still fail to understand such an important difference. The tribunal may recall that the claimants underestimated in this damages phase and even went on to state that this was a simple case and without any special expertise, and they repeated this in their opening today, and that they would claim the maximum amount under Contract 821. At the outset, the claimants did not present an expert in damages, but then they undid their decision and submitted a report together with their reply on damages with the sole purpose of supporting theories that had already been developed previously by counsel without the advice of an expert. And it is incredible that to date, claimants have not demonstrated, in my opinion, basic issues in an investment arbitration, such as whether they used their own resources or whether they participated in any way in the performance of Contract 821. And here, the key aspect is that the tribunal should not award compensation for damages that have not been proven. Secondly, the claimants' three theories are flawed and unfeasible because, one, they intentionally fail to consider what we have called in this arbitration the Tucma award, that is, what a Mexican court already determined was not mandatory to exercise the minimum contract amount. Second, they have not provided evidence that they have suffered any economic impact. Three, assuming that there were economic impacts, the truth of the matter is that they only used one drilling rig under Contract 821. Four, the claimants are seeking compensation for the time period between work orders, which is contrary to the tribunal's findings and the claimant's own statements. And five, these four theories that have been put forward by the claimants bear no relation to the findings by the tribunal under NAFTA. And finally, the claimants are claiming lost profit because of the finiquito, the unilateral finiquito in the Dorama bond, and also some losses because of the litigation in Mexico. However, these losses are not to be compensated because they have not suffered a loss in relation to these items. And in addition to what I just have mentioned, we will explain why the interest sought by claimants is not justified in the circumstances of this arbitration. Why? Basically because they exceed the full reparation and because they would be punitive interest, which is expressly prohibited under Article 1135 of NAFTA, which we'll also address in detail in a couple of minutes. As to the first item, Mr. President, members of the tribunal, an investor, that is the claimant, does not have an automatic right to receive compensation in the event of an internationally wrongful act. This is not something that I say just by myself. This is what we clearly see in the articles on the state responsibility of the International Law Commission. That is, state is mandated to repair only damages actually caused by a violation that has been proven. But the burden of proof in connection with the amount of the loss and the causal link of the violation rests solely, members of the tribunal, with the claimant. And this was confirmed, for example, as we see it here, by two leading authors on this subject and a very large number of awards in investor-state arbitration. And the consequence of this is that if the claimant fails to meet this burden of proof, basically there can be no compensation awarded. It is not for the respondent, much less to the tribunal, to speculate about scenarios that have not been proven. The award in this case must be based exclusively on the evidence actually provided by the parties, and that is part of the record. And this is the reason why the existence of the loss and also its quantum must be proven with a reasonable degree of certainty, and they cannot be based on speculation or uncertainty. And if this is not the case, then the tribunal must reject the claim for damages, even if the state's liability has been established in the decision on jurisdiction and liability handed down in November 2024. And in particular, when the claimant claims revenue that it would have allegedly received had the violation not occurred, as in this case, it is essential for that claimant to provide solid evidence to support the alleged future activities and projected cash flows. But here, we should recall that numerous investment arbitration tribunals have been consistent in rejecting claims based on projections that are not properly supported. And not only that, Mr. President, it is not sufficient to demonstrate the existence and amount of the loss. Let us now look at something that is highly specific, and based on Articles 1116 and 1117 of NAFTA, the damages claimed must have been suffered directly by the investor or by an enterprise owned or controlled by that investor. Let us now look on the screen what they have. The use of phrases such as an investor of a party, the enterprise of another party, and what is even more important, the phrase as a result of the violation
of that breach. ¿Qué quiero decir con esto?
What do I mean here? In plain language, those companies or persons that have not participated in arbitration will not be entitled to compensation for damages. And now let us remember something very clearly. The claimants here are Finley Resources, Inc., MWS Management, Inc., and Price Permanent Holdings, LLC, together with some vehicles incorporated in Mexico. But Let us step back for a moment. At the outset, it was priced through the Bissell subsidiary in Mexico, and recalling now that they were contractors in contracts 803 and 804, but given that the claims filed in this arbitration under the USMCA related to these two contracts were rejected by the tribunal, let us say that MWS and Bissell were excluded from this quantum phase. Therefore, they are irrelevant at this stage. Now, in this case, it is relevant that under contract 821, only Finley Resources, Drake Mesa, and Drake Finley participated. These two subsidiaries controlled by Price and Finley. And here it is highly important to emphasize, Mr. President, that throughout the arbitration it has become clear that in order to perform contract 821 and the apparent investments, the claimant used a group of entities that were not part of the contract 821, and what is even more important, they are not claimants in this arbitration. And I am referring, for example, to Baku Energy Partners, Baku Exploration and Production, Drake Mesa LLC, Royal Shale Holdings, and Royal Shale Corporation, which, I repeat, are not claimants in this arbitration. And not only that, Mr. Finley and Mr. Kernion are not claimants in this proceeding either. And all of this connects directly to something that the tribunal pointed out in their decision on jurisdiction and liability that you can see on the screen. Basically, the one that determined that in the abstract, the claimants were owners of corporate entities that did qualify as investments, but the tribunal was clear that it did not determine that whether all of the items were actually investments protected by NAFTA, and more importantly, whether the claimants, and here I am referring to Price and Finley Resources, on their own behalf or on behalf of Drake Finley and Drake Mesa, actually invested more than $30 million in Mexico. And as shown here on the screen, the tribunal decided that in this damages phase, they would review the effective participation of the claimants, and it is precisely that analysis, the one that claimants had to complete with evidence, but they didn't do so. They failed.
¿No han demostrado?
So far, the claimants have not shown that they themselves committed their own resources, nor that they verifiably participated in the activities under Contract 821, nor have the claimants gone up to their burden of proof in terms of the alleged losses they've suffered. And there's something else reflected in the decision on jurisdiction and responsibility, where the tribunal decided that there needed to be information regarding the way that their investments were channeled, but only in a very reluctant and piecemeal way. The tribunal also decided that transparency, level of detail, the exhaustive nature of the information provided in this arbitration was not up to the regular standards that most parties, claimants follow when they try to describe the structures or the internal relationships or property and control over various entities and persons who directly or indirectly comprise the group of the claimants. So I think what they're saying is that it is not clear, it is messy, and they did not make any effort to provide any type of information that was necessary during this quantum phase. And in fact, the claimants continue to argue that they have no obligation to provide evidence. As you can see on the screen, they say they do not need to prove that they are the owners of the 10 rigs that they have mentioned, confirming that they do not have records about their employees before 2016, stating also that if someone else paid those invoices, the loss would remain with the new creditor because of subrogation, saying that according to them, they also provided the best evidence they have regarding the fees of certain attorneys, and they also confirm their position that for the claimants it's irrelevant whether those invoices have been paid, and more importantly, by whom. And what's even worse, they continue to try to confirm that in their view, if they did not pay the respective invoices, the loss remains. So clearly these arguments are groundless. And during the jurisdiction and responsibility phase, Mexico asked the claimants for copies of all their financial records, and the tribunal took note that the claimants stated that with the exception of those documents that were prepared for 803, 804, and 821 for those contracts, the reality is that they did not have records for the request for documents made by Mexico. And it's for this reason that the tribunal decided that it was not necessary to issue a document production order, because basically the statements of the claimants indicated that they did not have the financial records requested by Mexico. Considering that the tribunal already looked into this and the lack of evidence, the consequence is that the tribunal should be extremely skeptic about any attempt by the claimants to suggest that the Mexican entities now have available to them these financial records. And this is an atypical, unusual situation. The claimants have tried to distract from their own lack of evidence by complaining about the document production by Mexico. But we should remember that the claimants refused strongly to have a production phase for the documents during the quantum phase of this arbitration. But to go back to what we've already discussed regarding jurisdiction and responsibility, we should remember that the invoices submitted by the claimants show that the purchases were done by other companies, not the claimants, and that these are the personal property of Mr. Finley and not of the claimants. Also in this phase, Mr. Kernion stated that Drake Mesa hired personnel to work under Contract 821, but he did not show any labor records, financial statements, or other records that show that Drake Mesa, in fact, had any kind of employees. They simply presented a list of fired employees that does not say what company they worked for, much less does it say who made this list. And we should also emphasize that all the employees on this list were hired much before Contract 821 went into effect. So clearly expressed, the claimants showed no additional evidence during this damages phase to fill this gap of facts. And this only shows their non-compliance with the burden of proof that they had. They're also claiming legal fees for certain law offices, but all they submitted was a combination of invoices with statements by Mr. Kernion that did not prove the payment of these services, nor do they identify the person or the company that released these payments. Also, these invoices do not have a detailed description of the services rendered, and this makes it impossible to determine whether the invoice services and also to what extent these actually correspond to the relevant events for this arbitration, or whether they are related to matters that are completely different from our case here. It's also relevant that the claimants and Mr. Kernion simply offered general estimates about portions of these invoices that they consider related to this arbitration, but if they offer no evidence, nothing to base it on, some document that allows the tribunal to verify the reasonableness of these claimed amounts, or whether they are relevant. Also, the claimants, not only did they need to show their losses that they're claiming, but also to back up any opposition to the damages valuation proposed by Mexico. They and their experts simply ignored this important element, and this was part of what was their duty to fulfill. So in other words, the claimants and Mr. Manes simply criticized the FTI valuation, but they showed no evidence, nothing to base their criticism on, nor did they provide specific inputs for a different valuation. So keeping in mind that we have these gaps in the evidence, we will explain the reasons why the claimants' theories are defective and fail to show the alleged damages that they're claiming. It's important to clarify once again what is the applicable standard for reparation, and that is full reparation. This standard has been established and recognized by the International Court of Justice for a long time in the Corso Factory case, and this is in Article 31 of the ILC, Article 31, and it says that you need to reestablish the situation that in all probability would have existed had the act not taken place. And this is very important, and it's also important to bear in mind that losses are usually compensated in two ways. The first one is damnum emergens, or consequential damage, which refers to sunk costs, which means that the money was paid by the investor, but it was wasted. The second one is lost profits, which refers to net profits that would have been generated. As you can see on the screen, these two are mutually exclusive. Not just one, several investment tribunals treat them as alternatives to each other. One claimant does not have a right to both. And regarding this case, Mr. President, the claimants would have incurred payments before getting a profit from this contract. In fact, as one of their emails confirms, one that we have discussed and which we will continue to discuss this week, the claimants were obtaining profits of approximately 10% over their expenses. So gross revenue, as the claimants are claiming, are not compensable under this principle of reparation, since they do not precisely represent the net loss of the party, which is what international law requires. So wanting the total of future income, but at the same time claiming recovery for all costs, is not acceptable, because it means that they want to have everything. They want to have their cake and eat it too. So this is far from the definition of full reparation, and this would be punitive overcompensation, which is specifically forbidden by NAFTA. And let's remember that it's the claimants who must establish the counterfactual, the but-for scenario to support their damages claims. It's the claimants who have the burden of establishing what situation would exist if, or most probably would exist, had the violation not taken place. But reality is that the claimants have not done this. In contrast, the claimants adopted contradictory positions. One first contradiction can be seen in the fact that they stated that the but-for requirement does not exist. Does not exist because their damages, in their view, are easily quantifiable. Mr. President, that is a statement that they reiterated today, but at the same time, they present three alternative but-for scenarios to support some of their theories. Simultaneously proposing three damages scenarios is inconsistent. And also, none of the proposals is correct. And reality is that it's not possible that Pemex would have, with all probability, paid the minimum amount. With all probability, would have paid an amount equivalent to that of the 809 contract. With all probability, would have paid the maximum amount. The claimants needed to choose only the most likely, the likeliest, most probable counterfactual scenario. It's not logical. It doesn't make sense. It's not valid to suggest three scenarios and for all of them to be the most probable one at the same time. Again and again, the claimants, and we heard it again today, claimed that it was a simple matter. That's what they said, without a need for any damages experts. And we see clearly today that that is incorrect. And this makes it clear that the quantum position of the claimants is seriously flawed. And this shows as well that from the beginning, the representatives of the claimants have acted in an erratic way. But that's not where the contradictions end. The but-for scenarios that the claimants presented to support their damages theories do not comply with what has been established by this tribunal, nor by Mexican legislation. Mexico is not responsible, not liable for the administrative rescission of Contract 821. That's very clear. The tribunal linked Mexico's liability to a decision by the Administrative Justice, Federal Tribunal of Administrative Justice in October 2018, which determined what we've called in this arbitration the 2017 annulment decision. And this is important because Mexico is only liable for damages caused specifically by that measure. And that's why the relevant counterfactual scenario is one where the Federal Tribunal of Administrative Justice considers the administrative rescission annulled. Then the parties could proceed to reach an agreement regarding Contract 821, as happened between Pemex and the 809 contractors. But in any counterfactual scenario, Contract 821 would not have remained in effect, as is being erroneously suggested by the claimants. And this has to do with the term of Contract 821. It had already passed. And in a few moments, my colleague will tell you more about the reasons why the Tribunal for Administrative Justice was not able to force Pemex to continue with Contract 821. For more detailed analysis regarding the explanations about the claimants' theories, and obviously, Mr. President, with your permission and that of the tribunal, I will now give the floor to my colleague, Rafael Arteaga. Thank you very much. Good afternoon, everyone.
Ingresos brutos.
The claimants are claiming revenue that they would have received under Contract 821. The problem is that they did not show any evidence about expenses that they claim to have incurred. Regarding the first theory, the claimants are claiming gross revenue that they would have received had Pemex paid the minimum amount, regardless of whether they did the work or not. This theory goes far beyond the principle of full reparations, since Pemex was not obliged to pay Drake Finley the gross minimum budget. This is not likely at all that Pemex would have agreed to pay the claimants these gross amounts without them having performed the work and having incurred the connected costs. In particular, Schlumberger and Weatherford, the contractors for 819 and 820, incurred in costs when they performed the works assigned under those contracts. This first theory of the claimants is erroneous for several reasons. First of all, and this is something that has been mentioned a few moments ago, the language of Clause 5 of Contract 821 does not establish an obligation for Pemex to have a minimum budget. The analysis will be brief. It uses the term ejercerá. According to the Royal Spanish Academy, this is a cultural institution which is the authority, the linguistic authority in the Spanish-speaking world. So according to them, this is the simple future of the verb ejercer. It is not an imperative form. The imperative form of this verb in second or third person would be ejerza o ejerce. And we emphasize this because Clause 5 does not impose upon Pemex the duty to spend a minimum determined amount. Simply, in perspective terms, it says what Pemex could spend or execute, which is confirmed by the use of the simple future tense. Secondly, and even more important, Mexico's judicial branch has already come to a conclusion about this. So we cannot interpret something that the Tucma decision does not say. But what did happen is that Pemex is not obliged to pay the minimum budget of Contract 821 in favor of the claimants. And what we see now is that the claimants complain, saying that this tribunal was partial towards Pemex, and they offer excuses after the fact for not having appealed this Tucma decision. But the facts are clear. The claimants did not challenge this decision, and any argument they make is out of time. Also, the claimants have tried to provide context for this Tucma decision, and they say that the contract had not concluded yet, but they also did not present any claims after the Contract 821, after its term had elapsed. Also, this tribunal has already determined that there is no trace of arbitrariness in the Tucma decision, nor has it represented any violation of NAFTA. This means that the Tucma decision is final, and it's evident that the claimants are being very silent about the decision by this tribunal. The claimants also want to use the testimony of Mr. Asali, which took place during the jurisdiction and responsibility phase, to justify this theory, as well as the treatment supposedly provided to contracts 809, 819, and 820. But the fact is that none of this supports their position. Regarding Mr. Asali's testimony, the claimant's conclusion is reached by manipulating the context completely. As we can see on the screen, there is a question by the claimant's counsel. And Mr. Asali expressly says that Pemex's obligation is, and I'm quoting here, to contract out at least the minimum of the works. This is a clear answer, and it does not allow for the reading proposed by the claimants. He described a minimum obligation associated with the contracted works, but it never said that Pemex had to spend that minimum budget. The rest of the claimants' arguments fail because they suggest that they deserve equal treatment to the one provided to the contractors for contracts 819 and 820, as if they were submitting a new national treatment claim. And this comparison should be rejected because this has never been formulated before during this arbitration. And in the decision on jurisdiction and responsibility, it was not determined that such a breach had taken place. And I'll say it very clearly, Pemex had no obligation to pay the minimum amounts established in these contracts. The fact that the works for contracts 819 and 820 reached the minimum amount for those contracts doesn't mean that the minimum budget was compulsory. Also, contrary to what the claimants suggest, Contract 809 does not confirm that the minimum amount was guaranteed. The Acta Circunstanciada of April 2018 confirms that the contractors for 809 were paid their non-recoverable costs, which they could prove, including daily rig amounts, and that total paid was to 809 was lower than the minimum amount of the contract. The claimant suggests that Pemex used reverse engineering to determine this daily rate, but there's no evidence for this, and the burden of proof lies with the claimants only. But the evidence that we see in the record also contradicts this situation. As you can see on the screen, the 809 contractors had requested a sum that was greater than what Pemex ultimately paid. This is the amount that the claimant's lawyers referred to. But to make this clear and to avoid any incorrect impressions, this amount was requested, but it was not accepted by Pemex, and it was not the rate that was ultimately paid. Finally, the analysis by Mr. Manes really does not support the position of the claimants. He simply takes for granted that Pemex would have paid the minimum budget, but does not even mention the TUCMA decision, which wasn't referred to in the materials that he used for his report, which means that this was not provided to the claimants. And this means that his analysis does not abide by the principle of full reparation and does not make sense. The second theory also has no legal grounding. And also, the amounts in dollars are excessive. The claimants believe they have a right to the same settlement as Integradora y Zapata, the contractors for 809. And this, even apart from the differences between the two contracts. And the claimants are forgetting that the basis of their theory, which is Article 1102 of NAFTA, is not a principle for damages, because damages must be based on the principle of full reparation. The basis of violation based on Article 1102 determined by this tribunal is that Pemex reached a settlement agreement with the contractors for 809, but that decision by the tribunal is limited to this. The decision by the tribunal says the following. It says PEP stopped issuing work orders to both parties. However, PEP reached an agreement with the Mexican companies, but did not do so with the claimants. It's clear that the tribunal did not analyze the terms of the agreement with the contractors of Contract 809 to evaluate damages. The correct counterfactual scenario is one where Pemex does reach an agreement with the claimants. This is precisely the counterfactual scenario applied by the respondent and its expert FTI. However, the terms of this hypothetical agreement are not determined by the breach of Article 1102. In other words, the claimants do not automatically have a right to the same terms that the 809 contractors had just because Article 1102 requests a treatment that is no less favorable. In fact, it is the responsibility of the claimants to establish the terms that with all probability they would have agreed upon with Pemex. Here, the claimants are seeking the same daily rates for the economic effects of time due to lack of work assignment by PEPs. These economic effects that were paid to the 809 contractors, they're requesting that the tribunal apply this rate to each one of the days in which no work was assigned for the PMX 805 rig. And also, they want the same rate for the entire period of the contract, the entire term of the contract for 2 other rigs that have not even been identified. To fulfill their burden of proof, the claimants must prove that Pemex would have compensated for the economic effects at the same rates as the contractors for 809 during the entire time for which they are requesting it. But again, the claimants have not complied with their burden of proof. For clarity, we'll explain Contract 809 first, which was signed in March 2013 and concluded on December 31st, 2013. Unlike Contract 821, the 809 contract required that contractors have not 1 but 3 rigs available during the entire life of the contract. After the termination of Contract 809, the contractors and Pemex negotiated a finiquito in August of 2015. These negotiations continued for several years, and in March of 2018, the 809 contractors sent Pemex a letter requesting, among other things, payment for the economic effects for the time during which there was a lack of assigned work and this derived from the rigs and the equipment that were available for that work. And they were requesting a daily rate of approximately $73,000 based on 3 rigs and the personnel that was there on site as well. They requested this for extended periods of time of between 20 and 68 days during which those rigs were idle. Pemex agreed to indemnify the contractors of Contract 809 precisely for those economic effects of time due to lack of jobs being assigned. But Pemex reduced that rate to approximately $42,000 and also reduced the number of days. So in the end, Pemex paid a daily rate of approximately $42,000 for a total period of approximately 320 days, which meant it was about $13.4 million in the end. And it's important to clarify this now. These were considered to be sunk costs, non-recoverable costs based on Contract 809. It is incomprehensible to us why the claimants are now questioning this and disputing it. The Acta Circunstanciada of April 9th, 2018 between Pemex and the contractors of 809 refers to that daily rate in paragraph 8 and says specifically that this was issued as a result and for non-recoverable expenses.
In the subsequent hearing on jurisdictional responsibility, Mr. Asali clarified that the unit price, the special unit price paid to the contractors, was a form of non-recoverable expenses. In their post-hearing brief, the claimants also referred to the daily rates as non-recoverable expenses. As can be observed on the screen, they indicated that Pemex internally asked for a calculation of the non-recoverable costs and unit prices, and then indicated that Pemex calculated this amount to be $42,167.14. The phrase "this amount" connects the phrase non-recoverable expenses with the daily rate. And not only that, in the decision on jurisdiction and responsibility, the tribunal used the same language used by the claimants. It's also fundamental to note that the claimants now adopt a position on this point that is contrary to that which they put forward in Civil Proceeding 200/2016. In that case, they sought the payment of non-recoverable expenses originated by the suspensions of work that occurred during the time period of the contract, and specifically for the following periods: 108 days from 14 November 2014 to 1st March 2015, 98 days from 8 August to November 2015, and 105 days from 16 January to 26 April 2016. These are the same time periods about which the claimants complained in the 2023 hearing during the phase on jurisdiction and responsibility. The tribunal will recall that the first period indicated by the claimants in which Pemex ceased issuing work orders was, and I quote, 100 days without any work order. Then the claimant said that although Pemex requested certain work, it was once again halted for 98 days during which, in its own words, there were more than 100 people looking at themselves looking at each other's faces with nothing to do, close quote. The claimants also said that the last period was 105 days when they mentioned that the work begins and ends, 105 days of observing the equipment and people doing nothing. Let us recall that the claimant's attorney showed the same graph that we have up on the screen while making these comments. Now, why is this so important? Well, because according to Contract 821, the non-recoverable expenses had to be documented. The contract establishes very clearly the expression duly verified. The claimants have not documented these costs. They've not presented any evidence of what it costs to maintain the equipment for those periods without work. Let's also recall that the third single judge court rejected this claim for their claim for these costs in the judgment in the Tukma case because the claimants were unable to show that they had a right to these payments nor a right to the sums that they should have been granted. So, in other words, the third single judge court dismissed the claim due to lack of evidence. The relevant part of the Tukma judgment is to be found at pages 101 and 103, and they appear up on the screen now. The tribunal can review it. The main point that we want to highlight here is that, as in the case of civil trial of 2016, in this arbitration, there's the same lack of evidence. The claimants have not produced a single document that shows the expenses they incurred during this period. It's simply scandalous that a company such as Finley Resources can begin investment arbitration and ask for $141 to $168 million for these costs without presenting a single document to show the costs. The claimants should not receive any compensation for these costs simply because the contractors under Contract 809 received similar compensation. Apart from this issue, the request for the daily fees is impacted by other clear evidentiary shortcomings. Let's analyze them one at a time. First of all, the claimants were not owners of the equipment, and their evidence about the apparent ownership of Drake Mesa, Mexico, of a drilling rig are actually questionable. Now, setting aside the fact of the sudden appearance of supposed invoices just before the reply on damages, the documents submitted by claimants are extremely informal, do not include details, and are of questionable validity. Ownership is the key point in this context, as was addressed earlier under Articles 1116 and 1117 of the NAFTA. Investors can only claim damages and damage that they have suffered directly or that have been suffered by the company in representation of which a claim was presented. If the claimants were not the owners of the equipment and or it was not acquired for its use in Contract 821, then the claimants did not suffer the supposed economic effects of the equipment being inactive. Once again, the claimants sought the same non-recoverable expenses based on time of inactivity in Civil Trial 200/2016. Yet the third single judge court dismissed the claim due to lack of evidence as required by Clause 17 of Contract A21, reiterating once again that this tribunal already determined that the resolution is in keeping with international law, which in our view means that the tribunal should give deference to the Tukma judgment. Now, the claimant's request for a daily rate covering 3 rigs also lacks any justification or foundation. It's been clearly established that the claimants only used one platform PMX-805, and the claimants themselves have already recognized in this arbitration that Pemex only asked for the work of that rig. They're not even able to identify the other rigs that they supposedly made available to Pemex. Annex DT1 requires that the claimants present just one drilling rig, and all of the orders were carried out with platform or rig PMX-805. In addition, the calendar entitled Movement of Drilling Equipment filed by the claimants in the stage on jurisdiction and responsibility confirms that only one rig was used, PMX-805. In contrast to this, in Contract 809, Pemex specifically requested that 3 drilling rigs be at the place throughout the life of the contract, which clearly is totally different from what happened in Contract 821. In addition, the number of days is exaggerated and contrary to the case that they presented earlier. As I indicated a few minutes ago, the claimants asked the third single judge court to grant them compensation for expenses incurred during 3 distinct time periods with a total duration of 311 days. I already mentioned them, but just for clarity, I'll state them once again. 108 days from November 2014 to March of 2015. The second period, 98 days, ran from August to November 2015, and the third and last such period, 105 days, from January to April 2016. This, I repeat, was also argued in the stage of jurisdiction and responsibility. And now, for the first time, and only for purposes of this arbitration, they're asking for more, actually much more. They want a daily rate for each day of the contract, including the days during the periods in which Pemex did make work orders. In other words, they want to be compensated for the brief intervals between the work orders, apart from periods of inactivity. Nonetheless, this request lacks any foundation. Indeed, it's not a serious request. The contractors in Contract 809 did not receive this sort of compensation, nor is there any provision in Contract 821 that grants that right to the claimants so as to be able to receive this type of payment. It's worth repeating that the claimants bear the burden of proof, and they bear the burden of establishing the terms of an agreement which, in all likelihood, Pemex accepted. And this makes it clear that the claimants are very far from meeting this burden. Finally, the claimants' third theory is not reasonable, for they don't have a right to the maximum amount of Contract 821. Once again, the claimants are unable to show that Pemex would have agreed to pay them the maximum amount in an agreement. They allege that they legitimately expected to receive the maximum amount, but actually this argument was already rejected by this tribunal in the decision on jurisdiction and responsibility. Moreover, we want to make it very clear that the tribunal never considered that Mexico had violated the claimant's legitimate expectations. To justify their claim, the claimants present screenshots of work orders from 2014 that make reference to the maximum amount of the contract. But actually, these work orders do not establish what Pemex did in 2018 in the context of an agreement. We explain this in detail in our memorials, but the claimants never refuted them. Rather, they repeated their complaints about the failure of Mexico to produce documents in the first stage of this arbitration. Those accusations lack any foundation, and as my colleagues will explain in a few moments. But at any rate, the documents they allege that Mexico hid or did not produce would not be relevant for an agreement in 2018. What is absolutely crucial is that the tribunal bear in mind that the fifth clause of Contract 821 states clearly, PEP is not obligated or will not be obligated to pay the maximum amount of the contract, close quote. The claimants have not offered any response to this, and therefore, once again, they have not met their burden of proof. Mr. President, members of the tribunal, with that I conclude my part of the presentation, and I will yield to my colleague Oscar Rosado, who will talk about the failings in the damages claims related to the unilateral finiquito. But subject to the tribunal's consideration, I think this could be a good time for a break.
So,
55 minutes.
55. I think we'd rather continue subject to, because later on we'll have another opportunity.
Perfect.
Thank you very much. I'm truly honored to appear before you this afternoon. As my colleagues explained a few moments ago, the discussion we'll have in these days is not about analyzing hypotheses or narratives of damages that have been artificially constructed by the claimants, but quite to the contrary. Under the NAFTA, the claimants must show with sufficient evidence that they suffered a loss or damage as a consequence of the conduct that violated the treaty. It's important to bear this in mind because claims tied to the Dorama bond and the unilateral finiquito fail for a simple reason. The claimants have not suffered any harm. First, the claimants asked for $41.8 million to, in their words, pay Pemex to cease its search for the Dorama bond. And that is how it was put in its memorial on damages. But in the reply, they put it somewhat differently. Now they are seeking this amount to pay the Dorama bond if it pays Pemex's claim. Now, these declarations reveal a core problem. The claimants are not claiming present-day damages. Rather, they are trying to obtain precautionary compensation similar to injunctive relief, which is not provided for under the NAFTA. Or basically, they're trying to obtain funds to face a contingency that is yet to be resolved. Yet the NAFTA doesn't allow for such types of claims either. Claims under Articles 1116 and 1117 of the NAFTA, which you can see on the screen, must refer to losses or damages that the investor has already suffered. That means that the NAFTA does not refer to possible hypothetical losses. Rather, it requires losses that have already been incurred. In this case, the claimants have not paid the amount of the bond, nor have they shown that they have responsibility over the bond, and they have not proven that Pemex can directly claim that they must pay the bond. In other words, they have not incurred this loss. Moreover, the scant evidence of the claimants shows that the bond was secured with properties of Mr. Kernian. Nonetheless, Mr. Kernian is not a claimant in this arbitration, and granting the $48.1 the $41.8 million to the claimants when they have not paid or secured or even shown responsibility for this amount would be forcing the tribunal to order a transfer that does not repair any harm, but rather that creates an additional benefit, which no doubt would be overcompensation. Now, in an effort to be a little clearer, we have Dorama, which is a guarantor, and the bond, which is a commitment that runs from Dorama to Pemex. And Pemex's right to the bond is, at present, the subject of litigation in Mexican courts. Now, if the Mexican courts order Dorama to pay Pemex under the bond, it is not clear whether Finley Resources, Drake Finley, or Drake Mesa would pay the bond, or they might even run the risk of Dorama claiming a reimbursement from them. The only thing that the claimants have shown is that assuming that Dorama is obligated to pay, then it could claim reimbursement for the collateral guarantees that it obtained. But once again, the only person who apparently provided guarantees for the bond was Mr. Kernion. And I repeat, Mr. Kernion is not a party in this arbitration. The reality is that the claimants are seeking to have Pemex not collect on the bond. In other words, the claimants are seeking some precautionary remedy that the tribunal is not empowered to grant. As we can see up on the screen, the NAFTA delimits the type of reparation that a tribunal such as this may grant. And they are monetary damages and interest or restitution of the property. Therefore, it is clear that the tribunal cannot grant precautionary measures geared to national litigation strategies or domestic litigation strategies. In addition, setting aside the lack of any loss suffered or incurred, the Dorama bond cannot operate as the basis of a damages claim because it is simply not an investment, for there's no evidence that the claimants have committed any resources of their own in that bond. The commitment of resources is essential to determine whether the claimants obtained their own resources over that bond, so as to make it qualify as an investment. It's the absence of a commitment of own resources by the claimants that should not be, is not and should not be a minor detail. And to avoid any repetition, the same defect is repeated with the amount claimed of approximately $1.2 million associated with the unilateral finiquito. The claimants ask for this to cover charges which, according to their own hypothesis, Pemex might claim against them. Yet, once again, there's no evidence that the claimants have paid that amount, much less any evidence of a real and effective demand by Pemex, nor is there any show that the loss existed before the claimants had submitted their claim. Therefore, once again, there is no discussion of a loss incurred or suffered, and therefore this claim is outside of the scope of the NAFTA and outside of the scope of a full reparation. If one considers all of these requirements, the conclusion can be none other than that neither the Dorama bond nor the amounts associated with the unilateral finiquito can be compensated for in this arbitration. Moreover, in the reply, the claimants added about $9.7 million for a costs award obtained by Pemex stemming from the Tucma judgment related to Civil Trial 2016. This category should be excluded as well for two reasons. First, the claimants argue, we heard this in their arguments, that Pemex filed a recent lawsuit and that it is currently pursuing these things. That assertion is deceitful because it seeks to ignore the fact that the costs were legitimately issued to Femex after the claimant's failure in civil trial 200/2016. Therefore, it is not a measure it's not a measure that's been treated as a violation of the NAFTA. And to claim that Mexico should compensate the claimants this amount of $9.7 million because of a cost award is equivalent to asking the tribunal to reverse the outcome of domestic legislation. That is not part of the principle of full reparation, much less has it been shown that the tribunal has the jurisdiction to issue a decision along those lines. And with all of this, what we want to leave with the tribunal is the notion that the costs in favor of Pemex are not related to any measure in violation of the NAFTA, and that the claimants have made every effort possible to not carry out their payment obligations to PEP. Now, regarding the damages claims related to the claimant's litigation in Mexico, the pattern of shortcomings on the part of the claimants when it comes to verifying their hypothesis is the same. We have insufficient evidence, payments not attributable to the claimants, payments made before or after the violations, and claims that do not fall within the jurisdiction of the tribunal. Let us now go through these one by one. First, the claimants are seeking approximately $1.16 million in payments to employees derived from what they call terminations. Based themselves primarily on an Excel spreadsheet, which is up on the screen. It's a list that was created by unidentified lawyers in 2016, that is to say, before the violations of the NAFTA. This document does not meet any evidentiary standard. It does not show effective payments, nor does it show the identity of the payor, nor how these payments tie into Contract 821, nor the origin of the legal relationship under which those payments would have been made. We address all these points in our memorials, and the claimants are not able to refute them with any substantial argument. In addition, the documents put forward by the claimants show that a third company called Fast Export had carried out human resources activities, but there is no evidence that this company, Fast Export, had invoiced those amounts to the claimants. Indeed, the claimants, and we heard this again a few minutes ago, allege that Drake Mesa made those payments. But to this day, we don't know if they're talking about Drake Mesa, the Mexican company, or Drake Mesa LLC, an entity that is not even a claimant in this arbitration. So what is the conclusion of this? That the tribunal cannot grant damages for the losses of a third person or losses incurred by an entity that is not a party to this arbitration. But even if the claimants incurred those costs, there is an issue having to do with the time frame in which the payments were made. Why do I mention this? Because many of those supposed dismissals occurred in 2016 or before, that is to say, before the violations that are relevant for this case. And there's no evidence of payments after March 2018, which is the critical date. And as of October of 2018, the date of the judgment of the Federal Court of Administrative Justice, which in the claimant's narrative is tied to the denial of justice. And Mr. President, members of the tribunal, the payments prior to those dates cannot be attributed to subsequent violations. And the payments prior to March of 2018, the critical date, simply fall outside the jurisdiction of the tribunal. Finally, the claimants suggest that they could have recovered those amounts in a negotiation around the finiquito had Pemex not proceeded unilaterally. That argument doesn't make any sense. The standard should not be what might have happened, but rather what would have happened in all likelihood. And here, the claimants do not offer any specific evidence from comparative practice nor examples of Pemex reimbursing similar payments to other contractors. Plus, Pemex repeatedly invited the claimants, as you can see on the screen, to negotiate the finiquito, but they opted to not attend the meetings, refusing to participate, and thus, in fact, waiving their right to seek any reimbursement. Now, as regards the figures that the claimants seek for legal fees, the claimants don't even present any evidence that shows whether those amounts were actually paid or by whom. It is not reasonable or conceivable to argue that millions of dollars would have been paid for fees without keeping a single verifiable record of those payments. Some invoices alone do not show at all an outlay, plus the invoices do not describe services that would allow one to link them to the work related to the proceedings before the Federal Court on Administrative Justice. The claimants seek to make up for the lack of evidence with memories described in the conflicted testimony of Mr. Kernian during the hearing on jurisdiction and responsibility. But without evidence, it's impossible to verify whether those recollections are exact. Clearly, recollections are not documentary evidence. And even worse, as we see on the screen, in the testimony of Mr. Kernian before the hearing on jurisdiction and responsibility, he shows his lack of direct knowledge on this matter, as well as his failure to supervise such litigation. And like the claims related to the dismissals, here the time factor excludes some fees claimed, for a part of these would have been generated prior to the judgment of the Federal Court of Administrative Justice of October 2018. That is to say, before the denial of justice and before that violation, plus the fees incurred before 26 March 2018, the critical date, are outside of the jurisdiction ratione temporis of the tribunal. The combination of lack of evidence, lack of traceability of payments, and lack of jurisdiction stands in the way of granting any amount for these claims.
Finally, these claims also face an additional problem. They would be double recovery. As my colleagues described moments ago, the claimants submitted 3 proposals for damages, which, according to their own logic, include payments to the contractor that would have included labor and litigation costs. Full reparation does not allow for the stacking of items when they are already part of the compensation. And to conclude this section, Mr. President, members of the tribunal, the respondent would like to state clearly that the claimants present additional claims beyond damages based solely on possibilities or incomplete evidence. 1, the Dorama bond and the finiquito are not losses incurred or suffered. 2, the legal costs awarded in favor of PEP in relation to the civil lawsuit 2016 derived from a legitimate judgment and from a litigation that was not found to be in violation by the tribunal. And 3, the alleged labor and legal fees lack proof of payment, traceability, and are beyond the jurisdiction of the tribunal. With this, I would conclude my participation, and with the permission of the tribunal, I will give the floor to my colleague Gary Shaw, who will continue with the explanation of Mexico's position.
Good afternoon, members of the tribunal. I'm going to address the damages assessment proposed by the respondent and its experts. After that, I'll address the appropriate interest rate. I may say respondent, I may say Mexico, I may say us. In all three, I'm referring to the respondent. This is not a contract case. As we noted previously, the basis of the national treatment violation was that Pemex reached an agreement with the 809 contractors, but not claimants. To wipe out the consequences of that breach, the proper but-for scenario is one where Pemex reaches a settlement with the claimants. The same counterfactual is appropriate for the breach tied to the signing of the unilateral finiquito. To wipe out the consequences of that breach, the tribunal must assume that the finiquito, which is a settlement, was mutual instead of unilateral. The same counterfactual applies for the denial of justice violation. Had the administrative rescission been annulled instead of upheld, Pemex would have, in all probability, reached a settled the Contract 801 with the claimants. Claimants have argued that but for these breaches, Contract 821 would have, quote, remained in effect, and that Pemex would have continued issuing work orders to reach the minimum amount. Their position is wrong. Had the rescission been annulled, Pemex would not have been required to continue Contract 821. In our rejoinder, we addressed Articles 51, 52, and 57 of the LFPCA. That's the Federal Law of Administrative Contentious Procedure. We explained that the administrative court cannot order Pemex to continue with the contract. That decision is entirely within Pemex's discretion. Claimants didn't say a word about this. They didn't rebut this. Instead, claimants simply assume that but for the breaches, Pemex would have paid the minimum amount. That assumption does not satisfy their burden of proof. We already addressed the lack of the minimum payment obligation, but it's worth noting that in the but-for scenario, Pemex would not have agreed to pay the minimum amount in a settlement. Recall that Pemex opposed claimants' request for the minimum amount in the Tukma case, and their request was rejected by the Tukma court. And as you already noted in your decision, Pemex's budget considerations changed in 2015. Under these circumstances, Pemex would not have agreed to pay the minimum or continue issuing work orders on a contract that had expired. That's not probable. It's not even realistic. The only probable scenario is one where Pemex settles with the claimants. Now, regarding the terms of that but-for settlement, lost profits is the only thing that would have been available to claimants. Why? Because they would not have been able to prove sunk costs. The Tukma judgment confirmed this. Claimants couldn't identify those costs to the Third Unitary Court or calculate an amount. We put the relevant part of the Tukma judgment on your screen. You also quoted it in your decision. Claimants made a request for sunk costs to the court and told the court, "We'll figure out an amount later." The court rightfully rejected that request. The same thing happened in this arbitration. Claimants have not presented a single piece of evidence to justify what costs they incurred. The same thing would have happened in any settlement with Pemex. Claimants would not have been able to prove sunk costs, and Pemex would have rejected any such request. Why should claimants be awarded losses that they cannot establish? Lost profits is the only probable alternative, and it's entirely reasonable for respondent to propose lost profits. There's no dispute that lost profits is an acceptable form of damage in investor-state arbitration. Lots of investor-state tribunals have assessed damages based on lost profits, and indeed, claimants requested lost profits at paragraph 37 of their request for arbitration. Now they tell you that lost profits are absurd. Why? Claimants don't explain this. Not only are lost profits reasonable in this case, they are also quantifiable and reliable. Our damages experts, Mr. Jose Albero and Ms. Veronica Iristorza, used claimants' own data to assess lost profits. In simple terms, they took the gross revenues that claimants could expect to receive on the remaining amount of work and multiplied that figure by the profit margin that claimants reported to Pemex in 2015, in the middle of the contract. By FTI's calculations, claimants would have received approximately $27.5 million on the 15 wells that remain pending. Note that this amount, excuse me, what? It's the gross revenue.
Oh, sorry.
Yeah, sorry. I'll start that again. By FTI's calculations, claimants would have received approximately $27.5 million in gross revenue on the 15 wells that remained pending. Note that this amount is consistent with the $48 million in gross revenues that they received on the 27 wells that they had drilled. $27 million for 15 wells, $48 million for 27 wells. Those numbers are consistent. To isolate the lost profits from the lost revenues, FTI used the 10% profit margin claimants reported to Pemex. Now, claimants take issue with several parts of this analysis. We addressed all of those points in our papers. I'll limit my comments to some of the key critiques. First, claimants argue that Contract 821 did not have a minimum number of wells. But we explained in our papers that Annex DT1, the final version of Annex DT1, very clearly sets out a maximum and minimum number of wells. We've put the relevant page of DT1 on your screen. It very clearly says, and I'm translating this into English, the execution of these contracts is planned to be carried out in 3 packages with a maximum and minimum scheme, according to the following table. And you see that under Packet 5, which is the 821 contract, that there's a maximum of 81 wells and a minimum of 42 wells. And just for the record, the P stands for POZO, which means well. Numerous other documents support this maximum and minimum scheme. We presented an earlier version of DT1, which reports similar figures, a maximum of 101 wells and a minimum of 41 wells. We also presented a timeline from that earlier version. It's on your screen. That timeline showed the maximum number of wells planned for each year. The annual number of wells shown on this timeline is much lower than 42. Now, these numbers are slightly different than what's in the final version, but that's normal. Plans can change a little bit. What is important is that these documents confirm the scheme Pemex planned for the 821 contract. That scheme was based on a minimum and maximum number of wells. That's the same scheme reflected in the final version of DT1. Other documents support this scheme as well. This is C99 on your screen. It's a Pemex document that claimants submitted in the previous phase. It reflects Pemex's drilling schedule for the year 2015. And if you go to the third row, that's the schedule for claimants. We know that because it says PMX 805 below claimant's logo. You can't really see claimant's logo, but it says PMX 805 under the logo, and the PMX 805 was the only rig claimants ever used. The schedule shows that Pemex planned for claimants to drill 15 wells for the year 2015. Now, if we extend that schedule for the life of the contract, which is about 3.5 years, mid-2014 to the end of 2017, that's slightly over 50 wells total. That is consistent with the minimum and maximum scheme reflected in DT1. Now, it's important to emphasize again, if you can go back to the other slide real fast. It's important to emphasize again that this is not a contract case. The breaches are based on NAFTA provisions, not a breach of the contract. For damages, you need to determine what the parties would have agreed to in a settlement but for the breach. The reality is that claimants were drilling 15 wells a year, which is consistent with 41 wells or 42 wells total. The but-for settlement would have been based on the realities of the contract, on the realities of the performance of the contract. Now, a few weeks ago, claimants submitted a document that memorialized questions raised by the bidders and answers from Pemex. This is C229. Claimants discussed this document this morning. This document actually confirms that Contract 821 had a scheme of a minimum and maximum number of wells. Now, to give a little background, C229 appears to be 4 different documents combined into a single exhibit. It's 4 sets of minutes from 4 different meetings that Pemex held with bidders in November and December 2013. The minutes record questions raised by the bidders and answers to those questions from Pemex. There's 4 pages of this document. One of them's on your screen that displays a chart, or at least part of a chart. When you see that chart, that should tell you that it's the first page of one of these sets of minutes. But we caution you, members of the tribunal, that these minutes were not presented in any organized way. Most of the pages are missing. In total, these 4 sets of minutes contain 3,500 pages. We know that because the total number of pages for each set of minutes is at the bottom. Claimants submitted 18 pages of 3,500. The pages that they did submit were out of order. You can see that if you scroll through the document. We don't know why claimants submitted the documents like this, but we find it remarkable that claimants withheld nearly 3,500 pages of an exhibit that they submitted weeks before the hearing. In any event, this document supports respondents' request for lost profits. This morning, claimants showed you a page of this document with questions that were labeled number 237 and 238. We don't have these on the exhibit, but you can find, or on our presentation, but you can find them at slides 24 and 25 of claimant's opening. They told you that these answers confirm Pemex's minimum payment obligations under the 821 contract. But we ask you to review those questions and answers carefully. Those questions and answers relate to packets 9 and 10. It says it right above the question. Contract 821 was packet 5. Whatever Pemex was saying about the minimum budget in those answers does not apply to packet 5, or does not apply to contract 821. Now, if we go to the 15th page of C229, which is on your screen, you'll see that the bidders ask questions specifically about packet 5, contract 821. You see at the top of the page at question 286, it says, and I'm translating this into English, reference, packages 1, 2, 3, 4, 5, Annex DT1. The bidder asks, please update the table of maximum number of wells per year to be drilled, or if applicable, clarify the minimum number of wells to be drilled each year in those packages? Pemex's answer: the distribution of the number of wells to be drilled per year will depend on the start date of the 5 contracts and the performance of each contractor. Therefore, the number of wells to be drilled per year is indicative and not limiting. Now compare question 286 on your screen with question 237 claimant showed you earlier. That's slide 24 of their presentation. It's the same question, but the answers are different. The answer for the 821 contract talks about an estimated number of wells. It doesn't say anything about a minimum payment. The other question on your screen is important as well. This is question 290. It's on page 17 of this exhibit. Note that the same references to packets 1 through 5, DT1, the bidder asks, in the event that the minimum number of wells per year is not drilled due to causes attributable to PEP, lack of locations, waiting on casings, this is important, suspension of activity due to a lack of budget, how will PEP pay for equipment waiting times and other expenses generated by these types of events? Pemex's answer: PEP will not pay for waiting times and expenses generated as a result of waiting times. Compare this question with the one claimant showed you at slide 25 of their opening presentation. The question is the same, but the answer is different. For the 821 contract, Pemex does not reference a minimum amount. Now, their answer to question 290 on your screen confirms 2 things. First, contract 821 was based on an estimated number of wells, not a minimum payment. Second, Pemex confirmed in this answer that it would not pay for waiting times. In other words, Pemex told the bidders very clearly that it would not pay a daily rate for times when the equipment sits idle. Members of the tribunal, C229 directly contradicts their request for a daily rate, and it supports our use of the minimum number of wells to calculate lost profits. Now, shifting away from the minimum number of wells, I'll briefly address a few of claimants' other critiques, and I'll let Mr. Albero and Ms. Irastorza explain further. Claimants and their expert, Mr. Manis, critiqued FTI for using data from the unilateral finiquito, but FTI addressed this in their second report by using documents actually signed by claimants. When they used the documents signed by claimants, the changes were minimal. Mr. Manis also takes issue with FTI using averages in the calculation of lost profits, but once again, those averages are based on claimants' evidence, claimants' documents. There's nothing inherently wrong with using averages to calculate future profits, especially when those averages are based on claimants' past performance. Lastly, claimants object to the 10% profit margin, but that figure came from claimant's own employee, Mr. Alejandro Solis. Mr. Finley said in his testimony that this number is not reliable because he, Mr. Finley, never saw that document. But that makes no difference. Mr. Finley did not supervise the day-to-day operations. He told you that in the previous hearing. On the other hand, Mr. Solis was part of the day-to-day operations. He interacted with Pemex on contracting issues. Claimants can refute their employees all they want, but the fact is they've not presented any evidence to rebut their own 10% profit margin. So it's perfectly acceptable for our experts to use that figure. The last and always most interesting topic of these presentations is interest. We ask that interest begin to accrue on November 10th, 2021. This is the date that Pemex signed the unilateral finiquito and the first date Mexico became liable. Recall that you characterized the unilateral finiquito as an exercise of governmental authority. It was the administrative hook or administrative act that created jurisdiction rationale materiae. It was the only act that was directly attributed to Mexico in your decision. And you can find this discussion at paragraphs 294 to 299, and also on your screen, paragraph 795 of the decision. This morning, Mr. Porter said that interest should accrue when the state's responsibility first became engaged. Pemex is not a respondent. Mexico is the respondent. Mexico's responsibility was not engaged until November 10th, 2021. So interest should accrue on November 10th, 2021. This date also aligns nicely in the but-for scenario. There's no dispute that interest compensates for the time value of money, and November 10th is a realistic date when claimants would have been paid a settlement in the but-for world. You see a timeline on your screen. This is a timeline from paragraph 170 of your decision. Recall that after the the TFJA decision was issued on October 4th, 2018, claimants filed an amparo against the decision, and that amparo was decided in January 2020. Claimants then appealed the amparo, and the appeal was denied in March 2020. In all probability, Pemex would have done the same thing had the administrative rescission been annulled. Both parties have a history of appealing decisions that are related to this case. There's no basis to assume that but for the breach, Pemex would not have exercised its appellate rights, same as claimants. So the same timeline should apply. Applying this timeline, Pemex would have appealed the TFJA decision, and that appeal would have been dismissed in around March 2020. We think that it would have taken Pemex and claimants about a year to reach a settlement. Why? Because the finiquito for the 804 contract took more than a year, and the finiquito for the 803 contract took about 7 months, so a year is appropriate. And then another 6 months for Pemex to pay claimants. You roughly get it about November 10th, 2021. As far as what interest rate to apply, we ask you to apply a rate that's tied to the 5-year U.S. Treasury bond, or what has been called the risk-free rate. Claimants have requested compensation in U.S. dollars, so the interest rate should be tied to a U.S. dollar index. We clearly explain this in our papers. Claimants have in their reply relied on a U.S. dollar index. The reality is that the award, once issued, will be risk-free because it will be paid assuming it's not annulled. Mexico has always paid these awards. Thus, there's no basis to compensate claimants for any risk not taken. We make a few other points about the interest rates in our briefs. We're happy to answer any questions you have on those, but I'll stop here and give the floor back to my colleague, Mr. Bonfiglio.
Mr. Bonfiglio, I'm just looking at the interpreters, and I'm really concerned about their well-being. I was wondering, the tribunal itself is going to ask later on some questions about production of documents. Would you mind setting aside those 2 slides for the time being? Later on, you will be given the floor as the first speaker, and just jump now to your conclusions, and then we make a break. So, I mean, if we could skip right now, for the time being, slides 97, 98, and 99, which are on production, and that will be a separate request issue that we will discuss later on, and of course you will be given the floor first. So if you could just jump to your conclusions, the last slide, to relieve the interpreters and the court.
Con todo gusto, señor presidente. Dejando en claro.
Certainly, Mr. President, and also stating that this morning we heard serious accusations against the Mexican state. We do understand about the timing issue, and I will be brief as to the aspects for document production. and I will focus on the conclusions that the tribunal would like to hear right now, but certainly we'll go back to several accusations that we heard this morning. And now, in an attempt to encapsulate the conclusions to be presented by Mexico, Mr. President, members of the tribunal, we should address why are we here today. We are here today to reiterate that the claimants have not met with the burden of proof. We are here to reiterate that each of the three theories proposed by the claimants is flawed and exceeds the principle of full reparation, and some are not even linked, as I explained before, to the violations determined by this tribunal. We are here to reiterate that, as it was properly explained by Gary Shaw, this is not a contract dispute, and at any rate, the only feasible option, considering the circumstances of this case, is the loss of profits methodology that my colleague Gary Shaw explained in detail. The claimants' counsel explained in their opening arguments that they were shocked to see the counter-memorial on damages presented by Mexico, and what we said, that at the most, the claimants would receive about $2.7 million. But, Mr. President, there shouldn't be anything shocking because of this. That surprise or shock is the result of not recognizing that 2/3, and let me reiterate this for the record of this hearing, 2/3 of the claims put forward by claimants were rejected by the tribunal in their decision on jurisdiction and liability issued in November 2024. That is the result of presenting a case in a deficient manner, in not complying with the burden of proof, in compounding, mixing three theories on damages in an unsubstantiated form, and also in not being able to demonstrate what four claimants in this case could receive. And contrary to claimants and their counsel, we are not going to make inappropriate comments and incendiary comments against the Mexican state, clearly. There is no jury here. We have a tribunal with three experts on public international law and investment law. The truth of the matter is that Mexico does not conduct itself in the same way that the claimants do, as we have seen in this type of arbitration. And we are asking here the tribunal to be cautious with the comments that are being used by the claimants and the type of yellow press that is being used here to depict the respondent. But here we are trying to show the deficiencies, the flaws in the methodologies used by claimant, and flaws in trying to show here that there are only four claimants, the ones that are here in dispute. And clearly we see extremely concerned accusations against the Mexican state as to the phase that had to do with document production during the first phase on liability and jurisdiction. But it was the other party that did not want to have a document production stage in this quantum phase, and I imagine that they are regretting that right now. They are regretting that given the situation, and also they are regretting this in connection with their clients. But again, on behalf of the Mexican delegation, I'd like to thank you all for your time, and secondly, the patience that you have had to listen to all of the comments by the Mexican state. And with this, we conclude.
Break for 15 minutes? 15? Okay. 15 minutes. So 1-5, yes. So we are back. My proposal, particularly if respondent agrees, is to set aside the issue of production, in which later on we'll have a specific section, and you will have the floor first when discussing that topic, and then we go straight into the replies. So now the claimants have only 24 minutes for the reply, as opposed to 1 hour and 29 minutes for respondent. So, Mr. Metzheimer, you have the floor.
Remind me, are we doing post-hearing briefs?
Yes, of course, we will be doing post-hearing briefs.
I can address my observations in a post-hearing brief that I heard. It's not productive to respond what I heard.
By the way, something we haven't discussed within the tribunal, something which, at least for me, we would not exclude a priori, is that before you file your post-hearing briefs, we send you questions in which we will be particularly interested in, and for you to address on a voluntary basis in your post-hearing briefs. But definitely, there will be post-hearing briefs. We haven't discussed, and it's not in any procedural order, how long will you take to prepare those post-hearing briefs? But definitely, there will be post-hearing briefs.
Yeah, I mean, just to be clear, obviously, I have some comments about what I just heard, but I really don't want to repeat what I told you before, and I really don't think it's productive to, I can do it in a brief.
So you are skipping your reply now, and then probably respondent doesn't have to reply to itself. So we can...
Siguiendo lo que se está discutiendo.
In terms of what is being discussed right now, I understand the following. I think that the claimants prefer not to present a reply at this moment, regardless of the fact that it was in the procedural order or in the agenda for today. I understand that they do not want to do it right now. If we see the contents of procedural order 16, the parties and the tribunal said that there would be post-hearing briefs, and with the authorization of the tribunal, what I would propose is that between now and Wednesday, between the parties, we can discuss 3 topics. First of all, how long we would need to submit those post-hearing briefs. 2, how extensive the document would be, thinking that 2 things could happen. The parties could include what they consider to be relevant to mention in that brief, what came out of this hearing, and also to respond to any questions that the tribunal might have after the hearing. And then based on that as well, the third point that we propose, or I propose, that the parties might discuss and try to find common ground in and tell the tribunal after the hearing, is to talk about the date for the cost statement, of course, after the post-hearing brief. And there might be a 4th topic we could discuss in parallel fashion, which would be the revision of the transcript for this session. And this, in light of what the procedural order says, this is what we would do. And as we always want to do in the Mexican delegation, we want to find common ground between the parties. So I'll stop here, and I would like to ask the tribunal if you think this would be a good way to proceed.
48 of procedural order number 16, there's a letter A which considers the possibility that prior to your filing the post-hearing briefs, we were to address a list of issues, not necessarily to be addressed in the post-hearing briefs, but to be dealt with on a contradictory basis between the parties. But that's just a possibility. I think it's fine for you to agree on the issues that you describe. And so we can stop here the parties' preparations, and now it would be for time for the tribunal to put to you the questions that we are interested in. And that will give you some hint as to what issues might be interesting for the tribunal. And on that basis, I now turn to my colleagues and to Alain or to Franz. You want to take the floor first?
I defer to the questions you wanted to put.
Okay. Well, okay. All right.
Solo una pregunta, señor presidente.
Just a question, Mr. President.
Give the floor to Spain for the
Okay.
answering.
Then,
I think on this it would be
okay.
fair that we
Let's then discuss the issue of document production first. And before I give the floor to Mr. Bonfiglio, two questions from the tribunal. The first one is that now we have a complete version of document C1A2, which consists of two documents. The second version of that document produced by respondent plus document R201 produced, by Clemens, plus the unredacted version of the last 8 pages, which is now document R201. Just as a minor favor, if you could consolidate those two pieces into just one single document, which would be, so to speak, the third version of C1A2, that would be, for filing purposes, easier. And my second question concerns one of the requests that the tribunal included in PO 15 concerning the production of documents by respondent, and there were specifically in that paragraph 23 of Procedure Order 5, letters B and C, a reference to two attachments of documents 182 and, well, not necessarily attachment, but there, under letter 2, we ask for Mexico to produce DT2 of the 809 contract, which was mentioned by Integradora Zapata in his comments, in his negotiation position. And we ask as well under letter C for the document DI Adicional 2, Catálogo Precios Unitarios, which is mentioned by Pemex in document C184. The tribunal's understanding is that those documents were bilaterally produced, or were they not? Because if they were bilaterally produced, we would be interested in having those documents. I'm referring to letters B and C of paragraph 23 of PO 15. And its status is unclear to us, and that's why I'm asking.
Señor presidente, si gusta,
Mr. President, if I may, I'd like to answer your questions with the help of my colleague Oscar Rosado. First, I'll answer the last question regarding what is mentioned in PO 15. But before that, regarding your petition and that of the tribunal to consolidate C182 with R102 and to translate from Spanish into English, please count on cooperation from the Mexican delegation. We'll work with the claimants to get this document ready as soon as possible for the benefit of the tribunal so that you can have this new version.
Because the last pages were in English, they were redacted, but in English. And to the extent that the redacted part were just figures, you can read in English the entire document. But you need to do some putting together of pieces. And if you can just send us a joint PDF, that will be better.
I think for contract 809, I think what you were asking was DE2, Annex DE2.
D2, yes?
There's two. DE2 is R190.
No, sorry. DT2 of the 809 contract. No. if you look at, could you look at PO 15, paragraph 23, letters B, which refers to DT2
I was getting there. DT2 is
of the
R200.
809 contract,
That's R200. Correct me if I'm wrong. I think
which refers is mentioned by Integradora in its request at the end of 1A2. It mentions two documents. One had already been filed by respondent. The other has not.
they have. Mexico submitted Annex DT2 to Contract 809 as Exhibit R200.
200. Okay. That. Okay. And it was filed for everybody, including the tribunal.
Yes, it was submitted by,
Okay.
I see that it was submitted directly by respondents into the file as R200.
Okay. So my apologies. And then, as to the second question, the formato DE2, which is mentioned by Pemex itself in document mm, in document 184, sorry. That was submitted as well.
As I understand it, please correct me if I'm wrong. Annex DE2 to Contract.
No, not DT2.
No.
It's,
DE. D is an elephant. DE2
to adicional.
to Contract 809 is Annex R190.
Okay.
Señor Presidente, miembros de la tribuna, si puede.
Mr. President, could I make a clarification? As the claimants say, and rightly so, DT2 is the annex that we call R200. But as regards DE2, additional to catalog unit prices, we sent a communication on 3 February 2026 in which we indicate that this document, which is sought by the tribunal, is already in the record. And it's at page 3 of C-184, filed by the claimants. It's page 3. This is the format called Format DE2 Additional 2 Catalog Unit Prices. And the document to which claimants made reference as R201 is the request by the contractors under Contract 809, which is at C-182. But in the version sent by claimants, that version was being tested so that it was this request, but it had not been tested.
Frankly, I haven't seen DE2 adicional. What I'm seeing as the last page of document 184 is this table, which at the top says formato D4. I don't know whether it's exactly the same or not. Well, definitely it's something not important, and we'll figure out how to get that. So my apologies if I overlook some of your of the documents you filed.
Just Mr. Bonfiglio, una pregunta.
Mr. Bonfiglio, a question. You just said DE2 additional, which is mentioned at paragraph 23C of PO 15, is equivalent to R190. This is what I just noted. Did I get that right? Because now I'm seeing maybe that's not the case. No, DE2 additional is already in the record, and it's at page 3 of claimant's attachment or exhibit C-184. That's why the respondent did not produce it as the tribunal had asked it to do, because it's already in the record at page 3 of C-184. Now, for the tribunal's clarity, On February 3rd, we sent a communication explaining these two items. And if I may, Mr. President, if you think it's appropriate, we can resend that communication, but it is in the record. It's just that we were guiding the tribunal in terms of the page at which it could be found.
I failed to read the heading of the third page of document C84, and actually at the top of that page it reads Formato DE2 adicional 2. So,
Pero en ese caso,
In that case, your mention,
so again,
lo que usted mencionó,
what you mentioned, R190, therefore, is not the response, or what's at C184, page 3. Is that also reflected in R190? No, the R that we mentioned was R200, and that reflects the document that the tribunal asked for, which is the DT2. Well, I'm asking about DE2. DE2 is at page 3 of C184, and R190 is a different document.
There's two documents. Annex DE is an elephant 2, and DE2 additional. DE2 is R190. You're correct. DE2 adicional is the third page of C190. C184. 184, sorry.
So apologies on my personal behalf, because that was my mistake, and failed to realize that we have got all the documents, so that's sorted out. So I now give the floor to Mr. Bonfiglio for him to address the production issues that he had in his presentation and that he couldn't explain.
Le agradezco, señor presidente.
Thank you, Mr. President, and to provide this explanation that Mr. Alain Pellet and you both reminded us of, I'm going to take the liberty of going back to the presentation in our opening argument, and I'll also mention some things that I heard in the opening of the claimant. It's very important that the tribunal take this into account. Regarding Procedural Order 15 and the criticisms of Mexico that entailed, well, saying that Mexico did not fully comply with PO4 on document production, and that's from February 2023. It's an issue that we've been discussing over the last 3 years, and recently it has been discussed before this tribunal. It's been analyzed by this tribunal, and it's been mentioned today by the claimant. Now, if we could travel in time a little bit, Mr. President, up on the screen, you'll see request for documents 15. This was put forward by the claimants, and basically there they asked for documents on the determination of a daily price with respect to contract 809, in which the claimants expressly identified 3 documents, including the official note with a long number. You can see this is under E. Obviously, I'm not going to read out all of those letters and numbers. I'll just call it 168-2018, dated March 22, 2018. Now, pursuant to the tribunal's order, Mexico produced hundreds of documents, including the one which we call document 1512. That's how we captioned it when we delivered the documents. And that document 15.12 is precisely official note 168-2018. With this, we are of the view that it should be clear that Mexico did comply with the claimant's request. Now, we understand that the tribunal considers that document production was somehow deficient, because this document was shown, 168, without the attached documents, or let me put it like this. The cover letter of Official Note 168 makes reference to these, but there's one thing that's important to bear in mind. We believe that it is important to make the following distinction. Request number 15, as you can see up on the screen, was not a request for documents in the abstract, but rather it was drafted and designed to request 3 documents with a clear nomenclature and dates. Now, the tribunal's order, as set out in PO4, did not make reference either to attached documents, to the 3 documents requested by the claimant. So what do I mean to say by all of this, Mr. President? The reality is that we act in keeping with what was requested. We acted in keeping with what was ordered by the tribunal. Once we had the order of the tribunal, we basically asked Pemex to look for this document, to give it to us, so as to subsequently produce it once it was found, following the specific requirements of the tribunal. Now, there's one thing I want to be crystal clear on, Mr. President. We do not call into question in any way the authority of the tribunal when it comes to ordering document production. And we understand that the tribunal is of the view that attachments to an official note may be necessary in order to understand it. We get that point. Nonetheless, the reference that the tribunal made to Procedure Order Number 3, well, with all due respect, we did not consider that it is applicable. And we didn't see that it's applicable because that Procedure Order 3 refers to the treatment of supporting documents attached to the main pleadings that the parties present in an arbitration. Indeed, in Procedure Order Number 3, the tribunal listed what types of attachments it was looking at or looking for when it drafted PO3. And here I want to be emphatic that the respondent had no intention whatsoever to frustrate Procedure Order Number 3, and much less, President, has it hidden information. We want to take this opportunity before you to make it clear that Mexico complied with the document production request as formulated 3 years ago. And this situation, Mr. President, perhaps could have been avoided had we agreed upon a document production phase in this quantum stage. But the claimants did not want that. Let me put it in other words, Mr. President, members of the tribunal. In March of 2025, when we were discussing what this quantum phase would look like, Mexico, the respondent, proposed that there be a document production phase. And, President, members of the tribunal, the fact that Mexico proposed that there be a document production phase shows that we haven't even the least intention to hide anything. At that meeting in March of 2025, I repeat, the claimant's representatives refused to have a document production phase. And not only that, at that meeting, the attorneys for the claimant said, and if we could show this up on the screen, we could put it up. We're going to put up on screen what we heard on that occasion in light of what we've heard today in their opening. Basically, the lawyers for the claimants said,
exercise for me to spend time to write disclosure requests to Mexico. ¿Qué quiero decir con esto, señor presidente?
What do I mean by this, Mr. President? The lawyers for the claimant refused to have a document production phase. But today, we've been criticized once again for supposedly having hidden documents in this arbitration, which is false. It's false because, I repeat, Mexico proposed that there be a document production phase for this damages stage. And one thing with which I'd like to conclude, Mexico cannot be sanctioned for the fact that the claimants sought documents in a deficient manner. Nor can Mexico be sanctioned for the fact of the claimants having refused to have a document production phase at this quantum stage. And the reality is that the record in this arbitration makes it clear that in no way has Mexico hidden any evidence, and it has abided by the orders of the tribunal. I place great emphasis on this, Mr. President, because I view with great concern not only the efforts of the claimants to try to bog down Mexico's, or paint with a dark picture, Mexico's way of operating in this arbitration. We reject that. We also reject any accusations such as we've heard again today. And for me, it's very important to make it clear on this day number 1 of this quantum hearing, because once again, Mexico has had no intent to hide documents, and it has not done so. And our conduct speaks for itself. We wanted a quantum phase. And for some reason that I don't understand, the claimants rejected the document production proposal. So I think that this senseless accusation leveled against the Mexican state should be rejected. With that, I conclude.
No, I was asking whether claimants want to make a short response.
We made our position known, and we defer to you to make the appropriate judgment of how you.
Ya dimos a conocer nuestra postura y les corresponde a ustedes de hacer la determinación. Apologies.
We've already made our position known on the matter. It's in your hands at this point.
Well, my hands tell me to go ahead and continue with the question. So if you don't mind, the tribunal will now raise issues about the presentations that we have heard this morning and this afternoon. In doing so, the three of us have a totally open mind. Nonetheless, there are some preliminary views that we have obtained from reading so many documents, but feel convinced that we have an open mind and nothing in any question will sort of announce any decision in the award. So my first question is addressed to claimants, because respondent has argued in its pleadings and today again that to the extent that we are here not talking about contractual breaches but about treaty breaches, there is a need to imagine a counterfactual or but-for scenario which assumes that the treaty breaches identified in the decision on jurisdiction and liability had never taken place. Frankly, I find this argument compelling because this is an investment treaty arbitration. There have been some treaty breaches as determined by the tribunal, and then you need to imagine what would have happened but for those breaches. In claimants' allegations, I'm somewhat unclear whether you accept that principle or you don't, because sometimes you seem to agree, and particularly your expert, but other times you think that you should go straight from the contract to damages. Can you accept that for the tribunal it will be inevitable to construct a but-for scenario, not necessarily along the lines of respondent, but along other lines, but a but-for scenario to assess damages, in my view, is inescapable, and I don't know whether my colleagues will join me in that understanding. But my question is, do claimants reject a priori the construction of a but-for scenario to determine damages?
We do not, but you are correct that we don't agree with what has been proposed by Mexico about what the but-for scenario would be.
Okay, then I find that logical. You accept the bad for scenario, but of course you don't agree with the bad for scenario as crafted by respondent. That's fair enough. And then my second question is now addressed to respondent concerning because one of the key findings of the tribunal is that Mexico breached the treaty because it failed to offer to the claimants a treatment not less favorable than it had offered to Integradora y Zapata. Then the acta incircunstanciada took place on April 9, 2018, and April 9, 2019. And the Villahermosa meeting in which Pemex decided to call against the Dorama bond took place on May 18 of the same year. So more than a month after the agreement with Integradora y Zapata. My question is to respondent, assuming someone in Pemex had embraced the idea that they had to treat the claimants as favorably as they had Integradora y Zapata, would the Villahermosa meeting have had the same result that it had? So would the Villahermosa meeting decided to call against the Dorama bond and continue fighting with the claimants? Or on the contrary, you could say, well, if they really embrace the idea of reaching a settlement with the claimants, someone in Dorama, the head of Pemex or whoever, should have said, well, let's give these guys some respite and let's treat them as we did with Integradora y Zapata. And that was May 18, 2018. And that's my question. In that counterfactual, what would have happened with the Villahermosa meeting in May 2018?
Just give me. Mr. President, to your question, which we understand I understand that you're asking if someone in Pemex had decided that claimants should have been treated as or equally as the 809 contractors that have changed the behavior starting in May 2018, and our answer is no, because claimants were still requesting the minimum amount in the civil case that had not been decided yet. And so we don't really know what would have changed by May 2018 because claimants were insisting on receiving the minimum amount. So there may not have been an agreement by May 2018. There may not have been any difference by May 2018.
Yes, but in the decision, the tribunal found that the Villahermosa decision was a breach of the treaty. And so we are considering now a but-for scenario. Mm-hmm. So you should imagine that the Villahermosa meeting didn't translate into a breach of the treaty. And the only way in which I can figure out that the Villahermosa meeting was not in breach of the treaty is that someone in Pemex said, let's cut a deal with the claimants along the same lines as the contract 809. So and Pemex knew at the time that they were asking the full amount of but that's exactly what originally the Integradora y Zapata had been asking. They reserved in the original finiquito, in the 2015 finiquito, they reserved the right for a full amount of the pending works. And that was exactly the position of the claimants. So I don't know why the fact that the claimants were keeping that position was an argument not to cut a deal, attempting to negotiate a deal with them as early as May 2018. Because an argument which you make in your pleadings, which I found somewhat difficult to accept, is that any negotiation with the claimants would have taken 3 years and would have ended up in a settlement in the year 2021. That skips the key finding of the tribunal, that and is not consistent with the bad-for scenario, because in a bad-for scenario, pretty early you realize that you cannot breach the treaty, and Pemex should never have called the Dorama bond, and therefore should have been ready to treat the claimants on similar terms as Integradora Zapata. But probably you have already responded to me. I don't know whether claimants want to make any, and I can ask another question.
I honestly don't know what Pemex would have done. We would have hoped they would have sat down with us. That's what we were trying to get all along. But here we are.
But and another related question is the other finding of the tribunal is that the October judgment of the Tribunal Federal was against the treaty. Therefore, in a bad-for scenario, we had to assume that in October 2018, the Federal Tribunal had decided that the rescission was against the law, and probably should have hinted that the tribunal saw some elements of misapplication of law, abuso de derecho, and in my view, that ruling, once known by the claimants and by the Pemex, have significantly increased the bargaining power of claimants, because you had a federal tribunal, an administrative federal tribunal, stating that Pemex had breached the Mexican law and had mistreated the claimants. And I assume that, politically speaking, someone in Pemex would have said, well, guys, the tribunal is saying that we rescinded the contract illegally, and they are even accusing us of using devious techniques to achieve that result. So my preliminary view, and again, I'm still with an open mind, but my preliminary view is that the settlement for between Pemex and the claimants would have taken place sometime in 2018, and at the very latest, very few days after the judgment of the Federal Tribunal, which was a second step towards pointing to the need for Pemex to change tack, and rather than maintaining a confrontational attitude towards claimants, to take a much more friendly attitude towards claimants and try to treat them along the lines that the Pemex had treated Integradora y Zapata.
So 2 points. You had mentioned bargaining power, but for the administrative court's decision. And I think that if in the but-for world, had the parties sat down to a settlement after that decision, going the opposite way, Pemex would have still had a lot of bargaining power. There are clauses in the contract that would have allowed Pemex to terminate the contract early. There may have been some costs involved, but again, claimants would have had to establish those costs in any settlement. Pemex still had a lot of would have still had a lot of bargaining power had they sat down to a settlement. To your question, I think about timing and when did the breach, or when would the settlement have occurred, I think that is relevant to the question of when should interest accrue. You had mentioned our argument about a settlement taking 3 years, and I think we made that in the context of our arguments on interest. As we told you today, and as counsel for the claimants agreed, interest should start accruing when the respondent Mexico's liability accrues, and according to your decision regarding attribution, Mexico became liable for these breaches starting on November 10th, 2021. So when the settlement would have taken place, I don't think would determine when interest should accrue in these proceedings.
Well, but there's a more basic question, which is the TUCMA judgment, because the TUCMA judgment was issued in April 2019. So if you had reached a settlement with the claimants sometime in 2018, the TUCMA procedure had been discontinued as part of the settlement, and therefore there will be no TUCMA judgment. So you have been making repeated references to the TUCMA judgment, but in a but-for scenario that you yourself are espousing can be considered to be inexistent, because what happened in the year 2018, nobody knew how the TUCMA tribunal would decide some months, particularly because there is another element. If in October 2018 the Tribunal Federal had ruled against Pemex, I wonder whether this would have not had any consequence for the TUCMA. It's another jurisdiction, but of course the claimants would have used that ruling from the Tribunal Federal to impress on the TUCMA tribunal the improper attitude of Pemex. So the TUCMA judgment would have never taken place, and had it taken place, we don't know exactly how it would have looked like after a previous judgment by the Tribunal Federal, which was against Pemex and in favor of claimants. So
I don't think we know how the TUCMA court would have ruled in this scenario. To my recollection, as you said, that the cases were completely separate, and I don't recall the TUCMA judgment relying on the administrative court's judgment, so we don't know. Also, the TUCMA case was started by claimants. So, I mean, what would have happened with the TUCMA case would have been totally up to claimants.
okay. I now move, and of course I am under the control of my colleagues, on a philosophical question which may be important. We have discussed, and particularly respondents, rightly so, have made that distinction in law between laws as damnum emergens. I don't know whether in Latin you should say emergens or emergens, and lucrum cessans. So damnum emergens is very clear, something, an expenditure which became wasteful, something that you cannot recoup, and that's pretty clear. And then you need to prove that loss. But the question of lucrum cessans is a different thing, because in my view, you can have at least three different concepts of lucrum. The first one is you fail to get revenue that you were expecting, gross revenue. A second concept is you fail to get net revenue that you were expecting. And the third possibility is you fail to get the profits, which is even netter than net revenues that you were expecting. By lucrum cessans, respondent uses the concept of profit. But sometimes when you fail to get a revenue, that can be considered, legally speaking, lucrum cessans. And why is this distinction important? Because whereas with respect to losses, expenditures, you need to prove them. With respect to lucrum cessans, you don't need to prove them. You need to just consider very likely that they would have taken place. So you don't need to present any invoices for lucrum cessans. You need to convince the judge, here the tribunal, that that revenue, in all likelihood, would have been forthcoming and the claimant would have got it. And my question then is, and I turn to contract 809, and my question is, in the settlement of contract 809, the amount which was given by Pemex to Integradora y Zapata, was it damnum emergens or lucrum cessans? The respondent has already said that it was expenditures incurred. But that doesn't fit with an element which hasn't been discussed today, but which I find quite remarkable. In the settlement between Pemex and Integradora y Zapata, there are two different rates for days when the Integradora y Zapata's rigs were at use. In the case of those periods of inactivity due to the Hurricane Ferdinand, the daily rate was $11,000, whereas the daily rate for the same inactivity for lack of orders, originally claimants, Integradora asked for 73,000, but they were finally settled at 42. But exactly for 1 day of inactivity, if the inactivity was due to Hurricane Ferdinand, the claimants got just 11K. Whereas if the inactivity was due to lack of orders, Pemex agreed to pay 42K. My impression for that huge gap, which you haven't discussed about, but is very relevant, is that in the 42K daily rate, there is an element of net revenue cessans, not profit, not gross revenue, and the fact that Integradora y Zapata asked for 73 and finally it got 42K suggests that the 42K was a net revenue. Probably in the course of the negotiations, Pemex would say, well, you're asking a huge amount, but you need to bear in mind that you would have incurred expenditures, as you have been arguing in your pleadings. And that would have been an argument for Pemex to reduce the amount sought by Integradora y Zapata. And that could explain that the figure came down from 73 to 42, to take into account those potential expenditures would have taken place had the 809 contract been carried out in its entirety, which it was not. And then my question is, and I address this question to both parties, the compensation paid by Integradora Zapata was really gastos no recuperables, or was something different? Because it's difficult that it was gastos no recuperables, because the gastos no recuperables were identical irrespective of the reason for the inactivity. So in the case of Hurricane Ferdinand, was 11K. In the case of lack of orders, was 42. So there is something which doesn't fit. My impression is that the response, the key to that riddle, is to think that Pemex really gave a combined net revenue figure, 42, for a day, for every day, for every rig. But I want you to disabuse me of this preliminary conclusion, which might be wrong. And again, the question of whether the 42K was for expenditures or was net revenue, foregone net revenue, is very relevant, because for expenditures you need proof. For foregone net revenue, you don't need proof. You just need the expectation that you will be getting that amount.
Just one moment. Two things. I think the 809 contractors, we'll think about this a little bit more, but the 809 contractors requested compensation for what they said, the economic effects of the lost times of failing to assign work. So that, to me, sounds like a cost. And I think Mr. Asili, in his previous testimony, described the payments to the 809 contractors as I'll use it in English, a non-recoverable cost. So that's our
But
view.
if that was the case, why was so different from the payment for the Hurricane Ferdinand?
My initial answer, and we'll of course go back and look at this, is that those costs were special because something happened, and the 809 contractors had to do something unexpected that wasn't part of their what they were originally contracted to do, or there was some extra work. And so that 8 million figure comes out of that situation, that unique situation. The daily rate is a non-recoverable cost, but it's on a different premise. Does that answer your question?
No, because if it was extraordinary, you would have paid more for Hurricane Ferdinand than for just equipment sitting idle because of lack of orders. You don't pay more for idle equipment because you don't get orders than for idle equipments being prevented from working because of the hurricane.
Well, they were paid the daily rates and the 8 million for the hurricane. So the 809 contractors were paid both.
You mean additionally?
It was all, yes, it was all one payment. I believe, again, we'll have to go confirm this, but my recollection is that C-182 or 184 describes several payments of non-recoverable costs, several different types of non-recoverable costs that were all paid together.
My recollection is that Hurricane Ferdinand was something like 8% or 10% of the payment made by Pemex to Integradora y Zapata. So it was a tiny, it was 1 million, 1 point something. Probably there is some document somewhere, and probably in the award itself. I haven't reread the award, but in the award there is a figure for the Hurricane Ferdinand and for the rest. And definitely the amount paid for the Ferdinand hurricane was much smaller than for the rest.
My understanding of your question, though, was that the rate for the Hurricane Ferdinand was in addition, or something more in addition, more meaning in addition to the daily rate. And that's, I think, what C-184 reflects, is that the 8% payment was something in addition to the daily rates. the 8 million payment was something in addition to the daily rates.
Well, okay. We can later on reflect
Yeah.
on this issue, and well, probably with Mr. Claiborne and Mr. Finley, we will be able to put questions on the distinction, particularly for lawyers, between a drilling rig and a workover rig. That for respondent is very important. And actually there is an article in respondent's reply explain the difference between a drilling rig and the impact on costs. Whereas I saw that this morning you underplayed the relevance of the difference between drilling rigs and workover rigs. And to be clear, my understanding is that you never had two drilling rigs. In the contract, you were supposed to have two, but you passed the initial test with just one. And later on, you had as many as 9 workover rigs available. But and then the question put by respondent, I think, is a fair one. Would you be paid the same for the daily rate of a workover rig than you would pay for a workover rig, for a drilling rig? Because in the case of Integradora Zapata, there were 3 drilling rigs. We know that there were 3 drilling rigs, and they would compare to your first PMX 801, but I'm not sure that they would compare to the other 9 workover rigs. So could you elaborate a bit on the distinction between workover rigs and drilling rigs?
So it's a bit of a misnomer to draw this distinction between a drilling rig and a workover rig. If you want to drill a very deep hole, that the rig that you're using doesn't have the capacity to drill, then you may need a larger rig, which is typically a drilling rig. We had 10 rigs. The rigs that we had were available to do workovers and drill wells. It depends on the capacity of the pumps and the motors, if you would be drilling a new well or drilling a workover well. Perhaps it's a little bit more complicated because, as you will ask Alan Claiborne, he's an expert in this area. I mean, Mr. Finley and Mr. Carrion can also answer this as well. But the other alternative is you have a drilling rig that's very large on a big deep hole. It drills the well to, let's say, the target depth, and then if you're drilling a horizontal well, you could move a smaller rig on to go horizontally. So this grand distinction between drilling rigs and workover rigs is interesting in the context of the case, perhaps, but the distinction is not as clear-cut. It's not like one rig says workover rig and says drilling rig. It's not the case. In our case, what's really important is there was a kit. You had to perform to accommodate work orders that could be delivered to you at any time by Pemex. And the work that was delivered was defined in the contract as in the minimum and the maximum. And the kit that you had to be sufficient. And I'm talking about the rigs, the equipment, the pumping, the people, to accommodate the demands of the work orders. So in the 809 contract, they had apparently 3 rigs. I don't know if they were drilling rigs or workover rigs or owned or leased, but they had, by reference to the documents, 3 rigs, and they had other kit to perform that contract. In our case, we had 10 rigs and other kit to perform our contract. And what's interesting about the 2 contracts is our contract is more or less 7 times as large as the contract in 809. but the time frame is 7 times as long. It's slightly shorter, which is why you asked the question earlier. That's the adjustment factor. We're doing approximately 7 times as much work in a slightly shorter period of time with a group of drilling rigs and support equipment and the staff to fulfill that obligation. I'm sorry for a long-winded comment, but the distinction that you draw between a drilling rig and a workover rig is a valid one given the context of our case. But I think you can ask the folks that do this for a living on a regular basis tomorrow about how each of these rigs, each of the 10 rigs, would be classified as drilling and workovers, and what you would have to do to the wells, and what was done to the well, to the rigs, to accommodate the demands of this program.
Okay. Many thanks, Mr. Darman. Tomorrow I'll ask more question about where were those 9 workover rigs sitting, and when were at least any of them returned to the U.S., but we can leave that for tomorrow. I will ask again about the 106 ratio, which I confess I didn't quite understand, because every day has 24 hours. So even if you have fewer times, every day remain with 24 hours.
But if you multiply the minimum and maximums in the 809 contract by 7, right? And what you find is it's almost, the 821 is almost 7 times as large. So the minimum and the maximum are almost 7 times. And the reason for the adjustment factor was to do the work, if you multiply the day, 214 days, which was the day in the 809 contract, by 7, it's a larger number than 1402. So we had to do, if you will, 7 times as much work in slightly less than 7 times the number of days. So for every day the kit was working, all right, there had to be a bit more kit to accommodate the overall program, because the program was 7 times as large, but the number of days wasn't quite 7 times as many.
If we may, can we
Yes,
just make just a very quick comment? You know, the issue with workover rigs and drilling rigs, that's all relevant. That's all related to claimants' costs. And with all due respect, they're kind of playing with numbers and showing you comparisons. The terms of the contract were different. The nature of the contracts were different. Yes, they were both drilling contracts, but there were key differences between those contracts. And so it's just not so easy to say, oh, well, one contract was 7 times larger than the other, so we deserve 7 times more. That's not the kind of comparisons that can be made. Thank you.
Just in fairness, this was articulated in our first damage submission.
And we refuted it.
I do not know that you refuted this particular aspect, but just to be clear and to keep everyone honest, you're not hearing this for the first time.
Our response is the same, whether it's, there have two theories. There's this adjustments that they're making. These calculations require documents. These claimants are trying to essentially ask for the same costs from a different contract. They have no documents, and so our response to the entire argument is you just don't have the evidence to establish these costs. Thank you.
Okay, my following question is one of legal interpretation, and to the extent that there are no legal experts, I know that you are a legal expert, I will address it to you. Because respondent has been arguing that in the contract, the only relevant thing was the minimum number of wells to be drilled, not amounts. And then the question is, you know this interpretation criterion for contracts, which is the effect utile. What was the useful effect? What's the practical implication of the references in the contract to minimum amounts? Because it's obvious that in the contract there are plenty of references to the minimum amount of the contract. Was that totally irrelevant in respondent's view, or did they play any role? Because my understanding of your position is that for you the word minimum amount was totally irrelevant. It would have been skipped altogether, and the contract would have been the same, which means that the argument cannot be right.
I think our position is that the references to the minimum amount do not establish a payment obligation on behalf of Pemex to, do not establish an obligation on behalf of Pemex to pay that minimum amount absent work orders. The contract references work orders as well, and so the minimum amount tied to work orders. If there were no work orders.
But then the question is, what is the legal effect of the words minimum amount in the contract? Because traditionally, if you put a word in the contract, it's for some reason. And you are saying that drafters could have skipped that reference to minimum contract, minimum amount of...
Just one moment.
Listo, señor presidente.
Ready, Mr. President. The position of responding with regards to this item is the following. The question that you're asking was already explained in the TUCMA decision judgment, and also analyzed in the contract, and also in the statements and the assertions by the parties in that case in the tribunal. The court reached the decision that the minimum is not that Pemex is compelled to spend the minimum budget, as my colleague Mr. Shaw indicated, given the absence or without the presence of work orders. Clearly in this case, there is a need to prove the costs incurred by claimants, but the reference to the minimum budget does not force Pemex to pay the minimum amount under the budget, and that is also because of budgetary issues. We should not forget that this is something that this is a contract that used public funds, and there should be some parameters to spend public funds and be able to conduct the work. So if there was no obligation for a minimum committed amount, there was an obligation. What was the useful effect? Because it was an idea that had been communicated to the bidders. And if it was communicated to the bidders, the idea was to give them some peace of mind, some comfort. Yes, and in this case, my colleague Mr. Shaw may be referring to this, but we should recall that the participants, the bidders were told information that was relying on the package and on the contract that led to their participation. In our contract, we mentioned that in response to the responses to package 1, 2, 3, 4, and 5, they had to do with minimum work rather than minimum budget. And that is also related to the minimum amount of work for 42 total wells under this contract.
To my final set of questions, and they concern the Dorama bond. Because you have yourself recognized that the methodology should be for the tribunal to wipe out all the consequences of illegal acts. The tribunal has already decided that calling the Dorama bond was an act against the treaty, and it was internationally illegal. So you agree that now the job of the tribunal is to wipe out all the consequences of the calling of the Dorama bond. But then you go on to argue that under the NAFTA treaty, the tribunal can only order monetary damages or restitution in the case of expropriation, so monetary damages, provided there is a previous damage. And you, in a compelling way, argue that you haven't called yet the Dorama bond, so claimants have not suffered any specific damage. So it's a future contingent damage. And so from that, I feel the uneasy situation that the fact that the tribunal has found that calling the Dorama bond to be against the treaty, for all practical purposes, is useless, because once, if we follow your position, we cannot say anything about the Dorama bond, and one day after the award is rendered, if the Mexican tribunals consider that you can call on the Dorama bond, you will, and you will seek 41.8 million from claimants. So would that not be a total disregard of the decision taken by this tribunal that calling the Dorama bond is an illegal act under the treaty?
Vamos a elaborar nuestra respuesta.
Let's prepare our answer to your question, and I think with your authorization, Mr. President, it would be useful to show slide 67 on the screen. If I had to encapsulate an answer for the question you've just asked, I would say that you are saying that the tribunal found that the Dorama bond, or going after it, would be against NAFTA. And if this is the case, then it's not compensable, that breach that the tribunal determined. I'll give the floor to my colleague, Oscar Rosado Pulido. And the claimants, remembering that we are talking about 4 entities, do not have a legal link or connection to the performance bond.
If I ask, well, the logical thing, yes, pure common sense would call for the tribunal to forbid Pemex to call against the Dorama bond. But I know that your response is going to be that the NAFTA treaty doesn't allow the tribunal to forbid Pemex to do anything, because that would be a provisional measure and is not within the powers of the tribunal to do that. Common sense is that you cannot do something which the tribunal itself has declared against the treaty. So that's out. We cannot, probably according to you, we cannot forbid Pemex and Mexico to call against the Dorama. But you say you can either give compensation for the amount of the Dorama bond because we haven't asked for it. We will wait until the Mexican tribunal decides on the issue. You then leave the tribunal totally toothless with respect to the finding concerning the Dorama bond, because and then you suggest that the claimants, if you decide, so we are dependent on the goodwill of Pemex to enforce and to not go against the Mexican tribunals against the Dorama bond. But in case you get a favorable ruling from Mexican tribunals and Pemex decides to go against the bond, then it will be up for the claimants to start a new arbitration, saying that was against the decision taken by this tribunal. So there is something which doesn't fit. Of course, sometimes, unfortunately, common sense is not necessarily always a good guide for decisions, but in this particular case, your reasoning leads me to some contradiction that we may rule that the Dorama bond cannot be called, but if you do, we cannot do anything.
I think if the Dorama bond case proceeds and the outcome is favorable to Pemex, that's because an independent court determined that Pemex was actually entitled to the bond proceeds. We're not here advocating for that. We're just being honest about the situation that Pemex and the parties are in. The choice is up to an independent court based on the evidence that's presented by both parties. The situation that you're describing about the tribunal being toothless, we didn't intend to put you in that position, and we're certainly not trying to, for lack of a better phrase, pull your teeth. But we are just applying the rules of international law, the terms of the treaty, and the outcome is just an application of those rules and those provisions. And so, I mean, yes, under the NAFTA, your powers as a tribunal are limited to monetary relief for damage that has already occurred. That's just
right. And you talk common sense when you say don't give 41 million to claimants because we haven't asked for that money yet. But you depart from common sense when you say you basically cannot do anything, and it will be up to the goodwill of Pemex and the Mexican courts to decide whether we can go after the $41 million, which is unsatisfactory for us, for me at least.
I appreciate that, but we have to read the treaties under the rules of treaty interpretation, and the powers of the tribunal are limited in that regard. And so it may be, as frustrating as it may be, we're just trying to apply the terms of the treaty.
Yes, but then if that's the case, then it's not true what you said at the beginning of your presentation, that the job of this tribunal should be to wipe out all the consequences of treaty breaches. Because in this particular case, with respect to the Dorama bond, the tribunal could not wipe out all the consequences, because one consequence is that you are still pursuing the Dorama bond, could continue even though it was declared a breach of the NAFTA.
We did say that the tribunal has to wipe out all the consequences, but I think what was not stated is that you have to wipe out all the consequences of previous damages, and you have to wipe out all the consequences within your powers as a tribunal. So if there are consequences that the treaty does not allow you to wipe out, there's little... we don't know what to do about that.
And what about...
Sorry for lack of a better phrase.
What about an alternative, which is to grant a compensation conditional on? So claimants are granted an amount which is subject to a condition, like in so many contracts, conditional on Pemex seeking before and getting the Dorama bond amount. Would that be, in your view, also against the NAFTA treaty?
That seems to require an awful lot of contingencies, right? Because the evidence on the record sort of suggests that in the event that, and it may be years from now, that the case is resolved, and all the appeals are done, and maybe Durama is allowed to enforce the bond. But there's no particular indication right now or reason to assume that the identified claimants in this case would be paying any money. So if you're going to set something up, we have seen evidence that Mr. Kernian, in his individual capacity, pledged certain real estate. And, I don't know what the status of that is. But even on a hypothetical, let's say Durama enforced against that, Mr. Kernian is not a claimant in this case. You can't award him damages, and you can't award damages to Finley Resources or Price Permanente based on a potential loss to Mr. Kernian. That's completely outside of the scope of this case. That's the point. And so, like I said, in theory, yeah, if something was going to happen in the next couple of months, but if it's, again, years from now, you'd have to determine whether or not any of these companies actually had to pay anything, and they might not. Very likely they would not. It's hard for us to see how you would structure that.
Because Mexican courts don't have to pay any respect to rulings from international tribunals. They can disregard altogether the findings of a ICSID tribunal under applying NAFTA. So they can say, okay, it's fine for you to enforce this Durama bond, even if it has been declared a breach of the NAFTA treaty.
This is an international tribunal formed under international law. It doesn't have jurisdiction over domestic proceedings. I'm quite confident that the United States and Canadian governments would tell you that a U.S. court has no authority to implement a tribunal's ruling on an issue of domestic law. It's just outside the scope. We're proceeding on a different plane here. Keep in mind, investment arbitration is a unique procedure, right? Governments have agreed to waive their sovereign immunity on a limited basis to deal with certain sorts of claims. It's not an unlimited invitation to invite international tribunals to make rulings on domestic law or issue injunctions or what have you. There's specific conditions for it. And in practice, it's been, there have been many awards, and, people can argue about whether it's working properly, but there have been many awards, and people have been paid money, and many claimants have lost. But it doesn't give this sort of authority to an international tribunal to give direction to a domestic court on how to interpret domestic law. It's just outside the scope. I hope that addresses your question.
Then you confirm my initial understanding that, in keeping with your position, once this tribunal issues its award, if on the next day you get a favorable ruling from a Mexican court, Pemex, that day could go against to Durama and ask for the execution, for the calling of the bond.
It could be years from now. It could be that Durama wins its case, but Durama is also not a party here. So it's just, again, there are limits to the tribunal's jurisdiction and powers that are set up under the treaty.
Any comments from claimants before I give the floor to my colleagues?
I did have a couple of observations. You make some astute comments on the Durama bond. I don't know. I'm trying to think about how you would fashion relief if you find relief is warranted under the circumstances, but I would assume nothing, although unusual, nothing prevents you from ordering Mexico to cut a check to Pemex for $41.8 million. We're not, if the concern is we're trying to seek a windfall, we're not. We want it to go away. And I think you hit the nail on the head. Sorry for all the expressions in U.S. English, but the Durama bond claim, if you think about it, it stems back to the unilateral finiquito. Its origin, the ability to make that claim on the Durama bond, is a penalty that Pemex assessed in the unilateral finiquito. So it's kind of, you need to if you think 2 steps back, you got to wipe out the, but for the finiquito, just to help you think about something else in the view. It's not just the Dorama bond. It's more than that. Not, I would say it is just not true under the law of subrogation and our contract with the Dorama bond. There it is. It's C-178. If this is paid, I showed you the next page, you know, the fine print that everybody signs that tracks law. Once it's paid, they come after all of us, Drake Mesa, Drake Finley, and Finley Resources. So it's just not true what you just heard. Thanks.
If, and that's just off the book right now, if the finiquito was declared by the tribunal to be in breach of international law, the unilateral finiquito, but I understand the tribunal has not made a declaration that it is null and void. It's just declared that it's in breach of international law, right? Have the defendants, well, would the defendants in a Dorama enforcement action make that argument that that enforcement would be enforcing a legal title that, even though not declared null and void, because the tribunal hasn't done that, but that it entails that deficiency?
It's a fair question, and I think it's a...
And just as a follow-up question, and would that argument be sufficient, would that argument be a kind of protection for the defendants in a Dorama enforcement action?
I think it's a fair argument, and it would follow from what Dorama did when Pemex tried to claim on the Dorama bond early on, before, you know, when it got rejected and had to come back for the unilateral finiquito after we initiated this arbitration. Your second question, though, is my concern. How much deference, as we just heard, possibly none, how much deference is a Mexican court going to give a defense that, oh, I have an ICSID arbitration, we're immune? Especially now that we've heard, also, you have no authority over Dorama. So it's really a claim, again, we're going to be the ultimate recipient of the claim. But the current claim right now is Pemex making claim against Dorama for the bond. Then Dorama makes claim by subrogation against us. That's what happens. So we can't really, as we just heard, we can't have Dorama go in with an ICSID award that says, no, I'm very sorry, Pemex, you can't make a claim from me because there's this award out there that I'm really not a party to. So I think the easier, that's why, and we struggled with this too, because we're not greedy. We really aren't. But we want the effects of the unilateral finiquito to go away. It never should have occurred. And so the only way we can do it, you have to somehow get Pemex paid. Whether you order Mexico to pay Pemex directly, you give us the money and let Pemex continue on with Dorama, release the hounds, let them fight it out, because they will. And I have no reason to doubt that Pemex will win before a Mexican court. Sorry, that's just my experience with this dispute. I don't think Pemex is going to lose. And then we pay the money. We're at risk.
Señor Presidente, nada más un comentario.
Mr. President, just a comment. First of all, we consider that it's inappropriate to think about a future of litigation that has not even materialized yet. And let's look at the hypothetical scenario. If there's a procedure in course in the claim of the Dorama bond, it's between PEP and Dorama, and we need to look at R005 to see if we can see how any amount can be recovered. But the basic point here is that these obligations are in some way guaranteed through assets, as we heard Mr. Kearney said, and we mentioned that in our opening statements. There's a huge difference between Articles 116 and 1116 and 1117 of the NAFTA, and there's already something diluted in the claims since the arbitration started, and we're looking now at just 4 investors who are claimants: Finley Resources, Price, Drake Mesa, and Drake Finley. That's it. Because we don't have as claimants that list of entities that I mentioned. Why aren't they here? I don't know. Why didn't Mr. Finley and Mr. Kearney submit claims in their own name and in representation of other entities? I don't have the answer to that either, but this tribunal is looking only at 4 entities. So trying again to encapsulate or frame this great question that you asked, I'll go back to what I said earlier. Not all awards that determine international liability consider or determine at the end that there will be compensation for damages. That's something that needs to be borne in mind, mainly because I think none of these hypothetical judgments has materialized that Mr. Melsheimer mentioned, and that in his opinion at some point could be favorable to Pemex. We don't know. That is speculation. Yes, Mr. Bonfilio, you are very sensitive to Mexico's image in this procedure. You've shown that regarding your considerations in the production of documents, etc. Do you not think that the fact that Pemex continues to go for that Dorama bond after the decision of this tribunal in January can be seen from the outside, at least by an unbiased observer, as an act of bad faith and of disregard for the decision made by this tribunal, trying to enforce an act that, according to this tribunal, was contrary to international law? It seems rather harsh, and there's conduct there, a behavior that I think could be considered to be in bad faith, but I'll listen to your comments. Yes, I'm sorry. I'd like to apologize, first of all, if there's any degree or any inference or hypothetically any suspicion by the tribunal of bad faith. This is a settlement, a dispute settlement procedure. So this is a serious accusation, and we take it seriously. But the fact that this has to do with the Dorama bond, this is related to the exercising of a right that PEP considers it has, it is entitled to, but not just that. It's also a hypothetical that has not materialized in anything. It is something that is still ongoing. So I apologize if that is the perception of the tribunal. But the truth is that nothing has materialized, and that's why we are here for these 3 days. And as my friends and colleagues have mentioned in Mexico's opening statement, that damage has not crystallized into $41.8 million. And ordering Mexico to pay $41.8 million of losses that have not materialized is just assuring a contingency recourse for something that hasn't happened. But would the Mexican government have the power to order Pemex to immediately withdraw its request regarding the Dorama bond in Mexican courts? That is a question that we'd like to think about. Also, we'd like to think about administrative liability that some officials might have regarding this procedure. I'm not trying to avoid your question. I can't give you a good answer right now, and I'd like to discuss it with my colleagues.
Are you done? We're not talking hypotheticals here. There's a reason why I started with the unilateral finiquito. Pemex is pursuing the Dorama bond because it is a security for the penalty that Pemex assessed in the unilateral finiquito. This is not hypothetical. We have incurred the loss when that unilateral finiquito was issued. We're now dealing with how to repair that loss. Thanks.
Okay, many thanks.
Well, on that, I think that, well, I have an opinion, but maybe I should keep it for my colleagues, but I think that a tribunal never can anticipate that parties will not comply with its decision. And there is an abundant case law, at least of the ICJ, on that. The problem is for the tribunal to be clear enough in its decision what is acceptable and what is not acceptable. But I don't want to prolong this discussion. Unfortunately, I have quite a relatively long list of questions, but my questions can be short, and it's more to give you some ideas what occurred to me listening to you, and you don't feel obliged to answer in detail. You will have. I am a fervent believer in post-hearings draft, so don't worry what you will say. Doesn't really matter, provided I have the answer later on. I would like to know if I have correctly understand Mr. Bonfiglio when concerning the attachment. Sorry to go back to this delicate issue. My understanding is that you said, well, our interpretation of the decision of the tribunal was that the tribunal wanted the document, and this did not include the annex. Is that your answer?
Profesor Pelé, gracias por su pregunta.
Thank you for your question, Professor Pelé. I'll give you my answer.
I can a bit.
You were very confident.
Yeah.
I will answer your question in the following way. Let's travel back in time to when the claimant requested these three documents that we saw projected on the screen when I talked about document production. They requested three very specific documents. One of them was the document 168 2018. So once the tribunal ordered the production of this, we, with the help of our colleagues, we looked for them, we identified them, and produced them. Then some time went by, and some doubts came up as to a specific communication that refers to other documents. And this situation, I think, has generated a lot of discussion. First of all, Professor Pelé, the claimant did not request specifically any document that had those three documents. They requested specifically three documents with their names and dates. As time passed, we understood that what the claimants were trying to do was also to obtain those documents referred to in those original documents. So Mexico never tried to hide any information or documents. We followed to the letter what the tribunal ordered us to do. Secondly, if in this quantum phase the claimant had thought about it and had said, I didn't just want those three documents, I wanted those three documents and also those documents referred to in those documents, that problem would easily have been solved with a document production during this phase, but they refused. And the third point is that eventually those documents mentioned on the cover of 168/2018, following the tribunal's instructions, those were exhibited. And that's very important. So I'm very happy and thankful that you've asked this question, because this gray cloud or suspicion of withholding of documents has been produced. But I'm glad you asked about it.
But you can answer by yes or no. But the documents which is at stake is an attachment, isn't it? C 168. We always had it.
82.
Pardon?
182.
182. Sorry.
Profesor Pele, deme un segundo.
Professor Pillay, if I could just have a moment, we're verifying this. It's very important that I give you a very specific answer, like you were asking, a yes or no answer.
La respuesta sería...
The answer would be that official note 168, 2018 was produced, and it mentions 3 documents, and those 3 documents were eventually produced in the arbitration. I don't know if there's anything else to add. I ask my colleagues. And I don't know if that answers your question.
Follow up on that. First, if it was not, now why is there any problem to communicate it, the attachment?
Tratando de hacer memoria.
Trying to remember this, we recall that request 15 of the claimants noted that they were seeking 3 specific documents, and we produced them. We did not understand that those documents were being requested plus any type of document that they might make reference to.
Sorry to insist again, but suppose that now the claimant or the tribunal says, we would like to have a look at that. Is there any problem?
Ninguno. Por supuesto.
None at all. Of course not.
I would like to have a look at that. I suppose my colleagues as well.
For the benefit of all, it's in the record. This is in the record. It's there.
I have others, maybe less controversial. If I find it, let's go back to this very serious problem of clause 5 and of the minimum or maximum. If I remember well, clause 5 is on the budget, is a problem of compensation. I think I probably have it as well. If so, I'm not sure how you say that. Well, I think it was Mr. Arteaga. You say that it is not a problem of budget, but a problem of amount, but a problem of work. If you take the clause itself, I am sure everybody can find it easily, even I, although I am very clumsy with these things. I think it starts with.
This is Spanish. No, but
why don't you take?
Right here at the end in English.
Yes, the minimum budget that PEP will exercise in the contract is blah blah blah. So just I want to understand why Mr. Anteaga, I think, insisted that, and you yourself came back to that as well. You say, no, it's not a problem of budget, it's a problem of works, if I understand well. How do you explain that, in view of the clause?
Sí, deme un minuto.
Yes, Mr. Pele, if you could give me just a moment, I'd like to see if we could get this clause up on the screen. Very well. The issue here is that before this contract was entered into, as the claimants have indicated, there were rounds for clarifying the public tender, which was divided into various packages, I think from 1 to 9. This specific contract, 821, arose from the public tender in what was known as package number 5. Now in package, but as regards package 5, specifically, questions were asked in which Pemex informed or reported that the contract was obligated to or linked to volumes of work, and this matter is also reiterated in Contract 821 when it is indicated that the work, that the work shall be done after work orders are issued. And it's also related to an attachment to the contract, which is the DT1. DT1 specifically, and as we note in our opening argument, indeed, I think we projected an image which establishes the minima and maxima of work, or number of wells that need to be worked on in the contract, for which work orders could be issued and they would then be paid. So it's precisely the relationship between these various elements that shows Pemex's intent with respect to this specific contract.
Okay, well, I think that the work must be translated into amount. But well, okay, I have your answer. This is what I had understood anyway. And well, still in the same line, I think it was Mr. Shaw who said, this is not a contract. And you, Mr. Bonfiglio, you also said the same, I think. This is not a contract case, and Mr. Shaw said also the tribunal must assess that the finigito was mutual instead of unilateral. Okay, I think it is tenable to say that, but what consequences do you draw precisely from that? Because it seems for you to be quite important, because both of you have stressed this.
The concept not being a contract case, I think, has been discussed. That is, we have to, for damages, we have to imagine what would happen but for these treaty breaches. We don't have to wipe away the consequences of a contract breach and ask ourselves what claimants would have received, what claimants were entitled to under the contract. That's the premise I believe that claimants are operating on, is they want in damages what they believe they were entitled to under the contract. Our position is that's the wrong question. Because this is not a contract case, you don't ask that question. You ask what happens but for the treaty breaches? What happens but for the unilateral finiquito? Well, our position is, but for the unilateral finiquito, there would be a finiquito or a settlement that was mutual. But for these other breaches, our position is there would be a settlement between the parties. That settlement likely would, the outcome of that settlement, likely claimants would receive a payment, but it's not automatically what claimants believe they are entitled to under the contract. You heard claimants' presentation today. They just said, we want the contract minimum. We were entitled to it, and we assume that but for the breaches, we would have received what we were entitled to under the contract. But this is not a contract case.
I suppose you have your say on that.
Yeah, I just go back to, what claimant's former, I guess maybe current expert told you 2 years ago. Excuse me, Mexico's expert said two years ago about Mr. Sali. Go back and watch the video. You remember him sitting right there. I think it might have been you talking to him. And the question was asked effectively about what happens if, the work's not being asked. He said, you pay the minimum. This is not hard. Contract 5 has a meaning. And this is not a contract case, but our losses are measured by the contract loss. There's no other way to measure them. You can't just ignore the language.
If I may. May I?
You absolutely may, yes.
Just 2 points. First, that's not what Mr. Asali said, and if you go back and read the transcript, you can review. He referred to works, not a minimum amount. The second thing is claimant's answer was based on a contract case. Assuming that the conversation with Mr. Asili is, as Mr. Malsheimer said, the question is what happens if you don't reach the minimum? That's a contract question. Mr. Malsheimer did not ask what happens if the unilateral finiquito is determined to be a breach, or what happens if the administrative court annuls the administrative decision. Those questions are based on the treaty breaches. Mr. Malsheimer's question was a contract question. Thank you.
Alan, Annalise is telling me that we are 143 minutes. I was wondering if you have, I think you have many questions. Would you mind if we continue with this session tomorrow morning?
Not at all.
Is that fine with you?
With the hopes that I find the building. But tomorrow I should.
Then we'll stop here, and thank you, and particularly the interpreters and the co-reporters. We're really thankful to you for your resilience and patience. And then we'll continue tomorrow with a short session with remaining questions from the tribunal, and then Mr. Finley will go straight to stand to act as with.
Would it be just for the sake of a gentleman's sanity, would it be possible for Mr. Claiborne to go first? I don't want to upset, if it's possible. Would that be okay, or?
No, we'd like to stick with the agreed order.
See you tomorrow. See you tomorrow.